Testing, testing, 1, 2, 3. Got it?
Rise. The justices of the Trust Division Supreme Court First Department. Hear ye, hear ye. All persons having business with the Appellate Division. Draw near to the attendant and shall be heard. You be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. Hope everyone is doing well. We have some 7.5 hours of argument scheduled this afternoon, so please keep that in mind as I call the calendar. Also, keep in mind that we have the briefs, we have your record, and we're fully familiar with the facts of your cases. I'm going to start by calling the calendar. Please note that today 2 of our justices are appearing virtually. Those of you who argue will be able to see them. The others of you will not unless you go downstairs. And also, when you argue, so that we make sure that everyone hears, including the justices who are virtual, please make sure that you stay in front of the microphone and speak into it, okay? All right. People versus Stephen Nucera. And how much are you seeking? Okay, 4, 1, and 4. Thank you. Jennings versus Silfen. Submitted. Sedina versus Marcus. Submitted. Ortiz versus the City of New York. It was 5 and 2. Okay, 5, 1, and 5. 122-24 Lexington Avenue versus Westco.
Appellate. 6 minutes and 3 minutes in rebuttal.
5, 1, and 4. New York Marine versus Eastman Cook.
Morning, appellate, 4 minutes, 1 reply.
4, 1, and 1, you said? What did you say, respondent? 1. Thank you. People versus, see, it is possible. People versus Michael Chilius, submitted. HSBC Mortgage versus Harb, submitted. Francis versus 41-21 28th Street.
Good afternoon, appellants, 4 and 1. Good afternoon, respondent, 4.
4, 1, and 4. Thank you. People versus Ivan Edmonds.
Good afternoon, appellant, 5 minutes.
I don't see that you have a respondent here. Do you wish to argue? I'll give you 2 minutes. 2 and a submission. Taylor versus New Jersey Transit. I'll give you 6, 1, and 6. Oberon Securities versus Titanic Entertainment. Submit, okay, sorry, I didn't. 5, 1, and 4. People versus John Robinson. 4, 1, and 4. Thank you. Camera versus New York City Taxi and Limousine. 4, 1, and 4. Hernandez versus 767 Fifth Avenue. I didn't hear you. You'll submit? I beg your pardon? 2 minutes. 2 and a submission. Nassau versus 1512 LLC. Five, 2, and 5. Caraballo versus Mount Sinai. 5, 1, and 4. People versus Simon Chodakowski. 6, 1, and 5. Cariugu versus Trustees of Columbia. 5, 2, and 5. Sofer versus Montanez is submitted. And then we have, sorry. And Article 78, which is DeJean Gamble versus Dennis Boyle. I didn't hear you, please. 5, 1, and 2. First case for argument is People versus Stephen Usera.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent Mr. Stephen Usera. We are asking the court today to reduce Mr. Usera's sentence to the minimum allowed by law. This was Mr. Usera's first felony conviction.
Counsel, it may be his first, but it was a violent felony, and that, I mean, I don't use the word violent in the legal sense, but in the practical terms. He said that he had a gun. He threw the woman to the floor, to the ground, struggled with the 80-year-old, and that was one of 2 instances in when he, this kind of robbery. So even though it is his, I think he had a YO, is that right?
Yes, Your Honor, he had a YO
And then he
had-
violated that with a couple of misdemeanors, which landed him in jail for 90 days, I believe. And then he has these felonies. Because of the aggressiveness, the fact that they are robberies, why isn't the 7 years appropriate here?
Sure, Your Honor, the legislature created this statutory range for this crime, and by making the 4 or 5 years indicated that in some cases that is appropriate. And our argument today is simply that given Mr. Uzera's young age, life circumstances, and lack of previous felonies, this is one of those cases. This crime, along with both misdemeanors, which happened in a very short period of time, is the product of a very difficult moment in Mr. Uzera's life. He was struggling to find a place to live. He felt coerced by people who finally offered him housing, and he was grieving his mother, who had passed away only 3 months earlier.
Where was he living before this happened? Because after the 90 days, I read that you just said that he felt that he found people who would let him. He was having trouble finding housing, and he went off with these two people who he said later coerced him into committing crimes.
Yes.
Where was he living prior to this? Before the 90 days incarceration, where was he living?
I am not sure, Your Honor, but I do want to address that housing point. By reducing his sentence, he won't find as bumpy a reentry. Now that he's our client, our office offers extensive reentry services, particularly in helping clients find accessible housing.
Counsel, excuse me, this is Judge Gonzalez. Was your client homeless before this all happened?
Your Honor, I do not know. That is not in the record. I believe he was living with his mother who passed away, but I cannot represent that for 100%. It is not in the record. But as I said, our office does offer extensive reentry services, so we can assist him with finding housing to make sure that he isn't in this precarious place once again.
So you indicated that he was coerced into committing these offenses. What was the result of the other people involved here?
So I know that Ernesto Jimenez Santiago was charged under a separate indictment, and he pleaded guilty to 1 count of robbery too.
And his sentence?
3.5 plus 5 PRS, Your Honor. As I said, no more than the minimum is necessary here. 5 years incarceration is still a significant amount of time, particularly for someone so young. Before this case, as you mentioned, the longest that he had been incarcerated was simply a few months. He admitted his role to the police when he was arrested. He took responsibility, and he pleaded guilty. If there are no further questions from the judges, I'll reserve the rest of my time on rebuttal.
Thank you.
Thank you.
May it please the court. Good afternoon, Your Honors. My name is Megan
Afternoon.
McLaughlin on behalf of the people. Now, as Your Honor has already pointed out, this defendant committed a series of extremely violent crimes. The defendant in this case approached 2 separate people on
He
2
did, and so we do know the facts of the case, but this is what counsel is saying. He had a YO, and then he violated and then committed these crimes pretty close together. And it seems like he was really having a difficult time at that period. And the most time that he had prior to this was the 90 days. So he had the YO, the probation, and then 90 days. To go from 90 days to 7 years, even given the fact that these were serious crimes, but they seemed to happen in this very short period where he was having certain issues, it seems. Why wouldn't the 5 years correct for, 5 years is not a little bit of time. Why wouldn't that correct for any kind of, behavioral issues? Why 7 years? Why is that necessary with somebody who's, I think, 25 years old?
Yes, Your Honor. While the crimes were committed about a month apart, so pretty close in time, they, as Your Honor has already pointed out, were extremely violent. Now, as to the exposure that this defendant was facing, he was actually facing up to 30 years for the 2 crimes.
Well, I understand, but, we would, I don't think any judge would have given 30 years. So the exposure is that as important as what is appropriate for this person with his age and his offense and his circumstances at the time? That's really what the question is. Isn't it?
Yes, yes, Your Honor. As opposed to, so between 5 years, which was what the minimum would be, and the 30 years, 7 years was appropriate
But
considering.
what about between the 5 years and the 7 years?
Well, the defendant, the circumstances surrounding the defendant's crimes were aggravating factors. These were violent crimes. One of the victims was extremely elderly. She actually ended up having to go to the hospital.
Well, counsel, while that may be true, the co-defendant got half the time he got, right? The co-defendant got 3.5 plus 5.
Yes, Your Honor. And while it is, the roles of each defendant are not extremely developed in the record because the defendant chose to take the benefit of the plea deal, the felony complaint does indicate that the defendant, this defendant was more of the leading violent actor in these crimes. According to the felony complaint, in the first crime, he was the one who removed the purse from the victim and handed it to the co-defendant. And in the second crime, the felony complaint indicates that it
Was there any development about what he said in terms of being coerced and being threatened and whether he lived with these people?
No, there was actually no development of that for similar reasons. The reference, I believe, that came from was from the police officer in the post-release supervision report, and that was just one statement by the police officer a year after the crimes were committed. There's no reference of that, to my knowledge, obviously in the complaint, and the defendant did not choose to speak during the sentencing.
So you have no information one way or the other who was leading whom? You only
Yes, Your
know
Honor.
that
The only information.
defendant did the acts that he did.
Yes, the source of that would be the felony complaint, which indicates that this defendant was the primary actor.
Right. So I ask
Excuse
again.
me.
Mhm. I ask again,
Excuse-
why isn't the 5 years sufficient? It's purely punitive then, because of the injuries to the 80-year-old.
Well, Your Honor, it would be because of the aggravating factors of the crimes that this defendant committed. The minimum would likely not be sufficient.
Why not?
Because this defendant injured.
5 years, and he's 25. Why wouldn't that be enough for him to understand that what he did in that short period of 1 month be sufficient? 5 years. I'm just asking for you to articulate it, explain to me.
Your Honor, it's simply.
Punitive,
Sorry?
punitive. It's simply punitive?
The circumstances surrounding defendant's crimes, it's the people's position it would not be appropriate for him to get the minimum total sentence.
Excuse me, just one clarification. The defendant pled guilty to robbery 1, and his co-defendant, Mr. Jimenez, pled guilty to robbery 2. Is that right?
That is correct, Your Honor, yes.
Okay, and they have a difference in their sentences as a result? That's
Yeah.
my question.
Yes, Your Honor, the co-defendant was sentenced and his case was under a different indictment. However, our records do show that he pled guilty to rob 2 and yes, had a lower sentence because obviously the minimum for that was lower.
Thank you.
Did he get the minimum in the range?
I'm not completely sure, Your Honor. I can absolutely check the range for you. And
Thank you. That's okay. Thank you very much.
thank you, Your Honor.
Counsel?
Thank you, Your Honors. I will be brief. I just wanted to clarify that Mr. Uzera is 25 now. He was 21 at the time of the offense.
Thank you.
The information about the coercion is, it's from the PSR and an officer statement, and I believe also in a recorded interview with Mr. Uzera himself. And if there are no further questions, I rest.
Nope. Thank you very much.
Thank you, Your Honor.
Thank you both. Ortiz versus the City of New York.
Good afternoon, Your Honors. Greg Friedman for the plaintiff appellant. I'd like to start with the misconduct issue if we can, and then if we have time to move on to the others, we will. We know what defendant's argument here is. Plaintiff's counsel did not move for a mistrial, so we're out of luck. But the interest of justice exception exists for a reason, and that's where there's conduct that can unfairly influence the jury's deliberations. I think that's exactly what happened here. I mean, look, a jury could say this Edwin Ortiz, he's a bad apple. I understand that. But from the direction that defense counsel took a trial, especially on summation, I think it's likely they were led into thinking that they should just throw this case out because Mr. Ortiz is another cog in the wheel of frivolous suit and lawsuits against the city. As I see it,
Counsel, if I may, but during the summation, the trial court did instruct the jury 3 times that counsel's summation, that they were remarks and not evidence, and even instructed the jury on the same issue.
there were curative instructions here. I don't think in this case they were nearly forceful enough. We have the cases in our brief
So
saying
what
that.
should the court have done?
It's almost hard to answer at this point because, as you could see from our cases, what counsel was saying as far as the experts being hired guns, this being a money-making scheme.
Well, counsel, isn't really the answer to my colleague's question, you should have moved for a mistrial?
I agree that that probably would have been the most prudent thing to do, but I also know that there are obviously cases that we've cited where other counsels similarly did not move for a mistrial, and they still were able to get a new one in the interim.
Well, that depends. That depends on what was said in those cases, and it also depends on the other evidence, because here there was substantive differences in the, I know you wanted to start with that because those comments were inappropriate for sure, and that's why the court addressed them. But substantively, you have 2 experts, and it seems that Dr. Avanezov,
That's how I pronounce it.
okay, didn't adequately contradict Dr. Tabador's findings. And so perhaps, you know, not perhaps, but so there was clearly a battle of the experts here, and it appears that the jury, based on the verdict, felt that Dr. Tabador's findings were more appropriate.
I think that's a conclusion defendants would like to make, and kind of my
Well,
instinctive...
look at the, you can, I'm sure you reviewed the record.
I haven't. My instinctive reaction to that is, if defendants' evidence, their expert evidence, were so strong and plaintiffs were so weak, why resort to these things on summation? This is not a case like the ones where defendants cited where you have 100-plus page summation where some improper...
Because some people just go there and it's absolutely inappropriate, and had there been a motion for a mistrial, maybe, maybe not, it would have been granted. But there was no such motion, and the court, time and time again, cautioned the behavior and gave a curative instruction. So, you know, why did the attorney go there? If the attorney were in the courtroom, I'd ask them that question, but they're not.
Right, but I think the case law stands for the proposition that where when comments by an attorney are calculated...
Repeat that, I'm sorry.
I'm sorry. The case law that we cite stands for the proposition that where the comments by counsel in summation are actually calculated to distract the jury, then that alone can be grounds for giving a new trial, even where there was no motion for a mistrial, because I think it was the language in the Bishon case.
So counsel, if I may, this is Judge Gonzalez. So what about, going back to Dr. Venisov, what about the fact that the plaintiff's own expert was unaware of his previous herniations, his previous claimed herniations, or the fact that the expert did not review certain records, wasn't aware that some of the symptoms complained of in this case for this incident actually had been reported earlier? What about those issues? Do the remarks of an attorney during summation overcome the difficulties that the plaintiff's own expert faced and was unable to address?
I think they do here without a doubt. When you have things like vouching for your own expert, denigrating plaintiff's expert, and not just with regard to what evidence he did or didn't review, but essentially saying that he will say anything for a price. He's a hired gun. We have case after case after this in our brief, and I think in this instance, there's more than enough to at least put that doubt in your mind that, did the jury really decide this case based on the evidence, or were they led to believe that plaintiff could be anybody?
Thank you.
Thank you.
Good afternoon, and may it please the court. Ben Pollock for the municipal respondents. This court should affirm the unanimous jury verdict finding that plaintiff did not sustain serious injuries in a 5-mile-per-hour fender bender in which he was wearing a seatbelt. Now,
Counsel, your opposing counsel started with his strongest argument, and obviously you're starting with yours, which was the substance of the case and the medical information testimony that came in and the contradictions in that testimony. But what about what counsel says about the outrageous behavior of the attorney here and the kinds of unnecessary comments that were made during summation? Why shouldn't we exercise our interest of justice power to reverse for those reasons?
yes, Your Honor. Well, as Your Honors have already observed, the issue is not preserved. Now, trial counsel for plaintiff, who was present, who heard all of these comments, apparently believed that they did not create a climate of hostility that so obscured the issues, and this is a legal standard, that the jury would not have been able to reach a fair verdict. Counsel speculated on a favorable verdict and lost, and now is trying to get a second bite at the apple. Now, in addition to the preservation issue, I would simply say that the city's best argument in response is the record itself. Now, plaintiff has addressed this misconduct at a very high level of abstraction and has made several supposed quotes. Plaintiff has referred to hired guns, someone who will say anything. These are in fact quotes from the case law, not from what the city's trial counsel said. And in fact, this is a pattern throughout plaintiff's briefing. I would like to just point Your Honor's attention, or call Your Honor's attention to a few places in plaintiff's reply brief at the top of page 6. Now, these accusations of misconduct sound very bad, admittedly, but they're at a very high level of generality. And if you look at the actual record citations, you will see that the record does not bear them out. In fact, it's nowhere close. It's very difficult to recognize what plaintiff is in fact saying if you look at the record. So on the top of page 6 in the reply brief, plaintiff argues that the city's trial counsel, quote, improperly instructed the jury on the law. He cites page 517 of the appendix. Now, if you go to page 517 of the appendix, what you will see is actually a colloquy among counsel and the court outside the presence of the jury. The jury simply is not being instructed on anything there. This is not an isolated misrepresentation. If you look also at page 6 of the reply brief, plaintiff again accuses the city's attorney of, quote, insinuating that Mr. Ortiz had brought a lawsuit in connection with his prior 2009 accident without proof. That's a direct quote. Now, I went to page 530 of the appendix, the page that plaintiff cites. On that page, counsel for the city's trial counsel, is in fact referencing the 2006 accident after which plaintiff did bring a lawsuit alleging many of the exact same injuries he's alleging here, including herniations to the same levels of the cervical vertebrae. These are 2 different years, and in fact, saying that the counsel for the city said that there were insinuations of a lawsuit without proof. We know that plaintiff brought this lawsuit because he himself admits it under cross-examination, and that's on page 159 of the record. Finally, in the exact same place in the reply brief, plaintiff alleges that the city's counsel, quote, this is a paraphrase, I apologize, but claimed personal knowledge of the facts. And I apologize for speaking quickly here, but there's some important things that I want to get through, and I know my time is limited.
42 seconds left.
Okay, well.
Use every one of them.
Thank you. Counsel cites 2 pages of the appendix, and on neither one is the city's trial attorney claiming personal knowledge of the facts. In one of them, what she says, she uses an idiom. What I do know, she says, is that it wasn't, just a little accident with no treatment. There were months and months of records of treatment. And this is referring again to that 2006 accident where a plaintiff was violently struck by an oil truck, mind you. And she's saying the plaintiff forgot, he omitted to testify about this under oath. He was on the stand, he was asked if he had injured his neck before, and he told the jury, no, I haven't, until he was impeached with his own medical records. I see my time is out, so if there are no further questions, we'll rest on the briefs.
Okay, thank you very much.
Thank you.
I'll try to be quick on rebuttal. I think in this case, it's worth actually repeating something from the record here of you did a fusion, you did a fusion, you did a fusion. NYPD car, make it a double. How is a jury supposed to objectively weigh the case after that? They won't, and I think that was the design. And I think the take home here is that a jury needs to have faith in the integrity of counsel to fairly decide a case here. And
I think we have to give the jurors a little bit more credit because the summation is not evidence. They're told the summation is not evidence, and then they get to go with the evidence and deliberate. And the evidence that they would have found here was that the plaintiff's own doctor acknowledged that the records from his office indicated that the plaintiff didn't even report his joint pain or numbness in his arms, that the plaintiff had full range of motion in his neck, which he said was so injured, and there was radiculopathy observed during a cervical compression test. And he acknowledged that his conclusions the plaintiff never experienced issues with his cervical spine prior to the subject action was based on what plaintiff told him, and plaintiff omitted the 2006 accident and other information. So I think maybe that's what the jury relied on and reviewed when they deliberated. Thank you, counsel. Thank you both.
Thank you, Your Honor.
One 22-24 Lexington Avenue versus Wesco Insurance. Yes.
Good afternoon, Your Honors.
Good
My name
afternoon.
is Deborah Denenberg. I'm representing the appellant plaintiff in this matter. This arises from what we deem to be a significant abuse of discretion by the judge on the trial court level in dismissing the case when there was a compliance conference that the court itself did not appear at.
Yeah, but that wasn't all there was.
I'm
I mean,
sorry.
that wasn't all there was. That was the May 6th, 2021 appearance, but I think there were several months before that that the plaintiff hadn't appeared and
No.
addressed the issue. I think it took 9 months until January 6th, 2020. And then I think there were contradicted responses during the deposition. So there was a lot of time that passed here. There was just one occasion where the court didn't answer the phone.
Okay, so, Your Honor, at the time of the May 6th, 2021 conference, all parties were in full compliance with all discovery. The only thing that was outstanding at that point in time was the filing of the note of issue, which had not been filed because defendant had not complied with the prior order to produce their witness on or before September 2020, and they did not produce their witness until January 2021. There was supposed to be a conference in March, I believe, and the court on its own adjourned the conference to May 6th per an email that is document 18 of the record with a phone number to call chambers when both parties are on the phone. As you will see in the record at 14 and 15, which is my cell phone, myself and defendant's counsel called the court.
Yes, we know that, the phone didn't answer on that particular day. But did the plaintiff
Counsel?
fully comply
Oh, I'm-
with the Is that Justice Scarpello? Go ahead.
Yes, I wanted to ask, so counsel, when were you supposed to do your depositions? When were you required to do your depositions? Because you just brought up the deposition issue. When were you supposed to get them done?
Plaintiff's deposition was completed timely in
No, no, no. When were you supposed to get your depositions done?
Honor, before September,
30th, September
September
30th.
When did you notice your first deposition?
oh, in 2020, I mean, a long time ago.
Yeah, December 16th. So you didn't even notice your first deposition until after the deadline had passed. And then your argument to us now is because you waited till December to notice it and the party didn't appeal till January, that's the other side's responsibility?
Your Honor, with all due respect, we noticed the deposition way longer ago than that. It was done with the initial discovery demands, and we attempted on many occasions to schedule that deposition, which was adjourned at the request of defendant, and it was held January 2021. So I submit that on May 6th, everybody was in full compliance with the discovery. And it's our position that it is abuse of discretion for the court to have sua sponte dismissed.
Counsel, what about the responses, the written responses to the first interrogatories? Because they were the subject of several orders. By my count, there were warnings. There's 4 sets of warnings, and again and again and again, the failure to provide written responses to the first interrogatories persisted, even as of the time of the fourth warning. I'm taking a look at all the warnings because there were a lot.
Your Honor, we produced over 4,000 pages of documents, and we
No,
don't.
no, I'm not talking about documents. I'm talking about something more specific, which are the verified responses were provided when January of 2020, after 3 sets of warnings, and you get 4 sets of warnings, and you're told this case is going out the window if you don't comply, and you don't comply. So is there supposed to be like a limited number of warnings that you're supposed to receive, or a maximum amount of warnings that you're supposed to receive when preclusion is the issue?
Well, Your Honor, as I mentioned, we fully complied. On May 6th, even at the
Late,
earlier,
untimely complied, right?
it was full compliance on May 6th, the date that the judge sua sponte dismissed the case. But for the failure of the court to appear on that date, plaintiff would have filed the note of issue, and we would not be here.
Counsel, if I may, as early as July 2019, you were first warned about dismissal. There were a number of failures. We talked about the failure to complete the depositions. There was also the failure to produce documents post the deposition and to file the note of issue by December 8th, 2020, or even to seek an extension. There were just so many failures here.
The note of issue wasn't filed because defendant had not appeared. And again, on May 6th, 2021, there was full compliance by all parties, but for the court not appearing. If we were
Thank you.
in the courthouse, like in pre-COVID times, we would have met in the hallway, we would have appeared before the judge.
Thank you.
I see my time is running out, so I just, in conclusion, our Court of Appeals in the case of Tripp versus Cook in 1841 made a very astute observation that's been repeated regularly. Judicial discretion is a phrase of great latitude, but it is never means the arbitrary will of the judge, and it's respectfully submitted that on May 6th, what the judge did was arbitrary, prejudicial, and unjust.
Thank you.
Thank you.
May it please the court, Kevin Buckley for Wesco Insurance Company. I submit that the trial court did not abuse its discretion in issuing the May 21, 2021 order. That is the order that denied plaintiff's motion to vacate That is the only order that is before the court. It is the only order upon which a notice of appeal was submitted to this court. In order to properly vacate such an order, this court has said numerous times the movement has to show two things: a reasonable excuse for its defaults, and the court has gone over that already. But the second element, which wasn't mentioned at all in the moving papers, was a meritorious cause of action. Plaintiff did not even submit any evidence whatsoever to the court to show that there was a meritorious cause of action here. In fact, there wasn't. If you look at the record, there are numerous record at pages 31 through 38. There are numerous sworn documents from the plaintiff telling the insurance company exactly the amount of their loss and swearing to it under oath. The undisputed amount of this loss was paid. After that money was paid, only then was a suit commenced against the insurance company to squeeze some more money out of it. Thereafter, we engaged in this discovery that went on for over 2 years, trying to get simple answers to interrogatories, simple documents, and reached obstruction on every turn. As the court has recognized, this was not about, the original order on May 10th was not about the failure to call in on one occasion. There were numerous occasions and numerous failures that resulted in this order. And I will not go over those as they've been pointed out by the court already. Finally, the order from May 10th was based not only on 202.27, but also 3126, which shows again that Judge Bannon did not issue her order just based on the failure to appear that day, but based on all of the evidence she put in her order for the failures of plaintiff to comply prior to that date. If there are no questions, I will.
Thank you.
Thank you.
Briefly, so 3126 allows for dismissal when there's outstanding discovery that hasn't been provided. And I again submit that we were in full compliance. All parties were in full compliance, so there was no grounds to dismiss the case under 3126. And 202, Uniform Rule 202.27 requires there be a default. And the only default here was the court's failure to appear, not the parties. So again, I submit that this was arbitrary, capricious,
Thank you.
abuse of discretion. Thank you.
New York Marine versus Eastman Cook.
Good afternoon. My name is Ann Odelson, and I represent New York Marine. Issue before the court is very simple and straightforward. New York Marine issued an insurance policy to Eastman Cook. It only covers claims for property damage that occurs in the New York Marine policy period, which is April 15, 2011 to April 15, 2012. Plaintiff is allowed.
How is property damage defined?
Property damage is going to be, it's going to be caused by an occurrence. And just to your point, the complaint
It was a question.
alleges.
It was just a question, not a point.
Oh, no, no,
I
I'm
asked
sorry.
you how was property damage defined?
Property damage is going to be defined by an accident or an occurrence that occurs within the policy period. And in this case, in the complaint, there are three distinct
Counsel, what
periods.
about that, counsel, what about that portion of the section of the policy which says that property damage includes all resulting loss of use of that property?
Yes, that is part of the deposition.
Isn't that the crux of
Completely
this
the
argument?
crux. The crux of this argument is we're alleging that we don't dispute. The complaint alleges property damage, which would be covered under the New York Marine policy. However, after the complaint was filed, based on deposition testimony and the verified bill of particulars, the alleged property damage during the New York Marine policy, their policy period, was paid by their insurance company or they received a rent abatement. So
Counsel, where in the complaint is it alleged that the plaintiffs received reimbursement? I know there's extrinsic evidence in the bill of particulars and some deposition testimony, but what else do you have?
What I'm arguing is that plaintiff's own admissions in the bill of particulars, which I would say the court can consider to terminate a duty to defend of an insurance company, where the plaintiff admits in the bill of particulars and deposition testimony that, no, I'm not seeking coverage for this property damage that occurred in an insurance policy period. So if they're not seeking coverage for that, there's no duty to defend, and that means there's no duty to indemnify because they've already been reimbursed for that property damage.
Okay, let's follow up on that, because paragraph 73 in the statement of undisputed facts, plaintiff acknowledged that it received a check from the landlord's insurance carrier for certain damages, but that she never signed a release because the insurance payment was a very small portion of the damages caused, and she was still looking to recover.
She was looking to recover also damages. I believe it was a sewage infiltrate. There was a sewage issue that occurred later on after the policy had expired. So while she was reimbursed for some of the damages that occurred in that policy period, our policy period, she was looking for additional money, and that was clarified, and we cite the different parts of the record, which wasn't within our policy period. It was for damages prior to the policy period and afterwards. But based on the record and
Why isn't there at least a question of fact as to whether or not the damage that she's claiming is part of all resulting loss of the use of the property? Why isn't?
Because, really quickly, because when she testified in other parts, the damages for all resulting use, which would be covered property damage, did not occur in our policy period. It was basically after our policy ended. There was a flood of some type. There was a backup of sewage. That was within the next policy period, not our policy period.
Okay, all right, thank you. Shortest argument time ever requested, I think perhaps in the history of the AD1 where there is opposing counsel. So, go.
Thank you, Your Honor. May it please the court, Thomas R. McLean, Abrams Gorlick for respondent Mount Hawley Insurance Company. Justices, the motion court properly compared the allegations of the complaint to the terms of the New York Marine policy and found clear duty to defend, just as New York Marine did in 2013. The motion court considered extrinsic evidence before it and found it was not sufficient to show that there was no possible factual or legal basis on which New York Marine would be obligated to indemnify the insured, and it applied a proper legal standard under the precedents which are cited in our brief. We respectfully request that this court do the same. In this appeal, New York Marine focuses on issues going to the merits of the underlying action, particularly whether Chapman and Bemis have been wholly compensated for damages incurred within the New York policy period, and that would include partial rents and property damages, which are not included in its property insurance claim, which is clear from the statements of fact, and that includes damage to floors. It includes its loss of use of the property on its inability to see veterinary clients during that time, which it would have received $1,000 per hour for its work. I think that's very clear from the deposition. Your Honors, the law requires New York Marine to defend the action, even if it's meritless. The claims for property damage and partial rent abatement in the Chapman complaint continue to be litigated to this day. We ask the court to act with the same caution as the motion court. What the court decides today will have no impact upon whether Eastman is ultimately liable for damages that Chapman recovers with respect to the New York Marine policy period. This court, the court in the underlying action will and should determine that, but this court could deprive Eastman of the insurance for which it paid premium to New York Marine. We urge the court.
So it's your position that Property damage, defined as all resulting loss of the use, covers that period that is following Hawley's period, that is within Marine's period of.
Yes, Your Honor, and it's partly because we know that Chapman and Bemis are seeking partial rents for that entire period, but also because we are in the coverage action. We are not in the underlying action, and so we are unable to predict how plaintiff may seek to prove her or the business's case when it goes to trial, and it's inappropriate at this juncture for New York Marine to essentially put Eastman in the position of plaintiff to try to prove plaintiff's damages. New York Marine's task is not, thank you, Your Honor.
You can finish your sentence.
New York Marine's task in defending Eastman isn't done. There's still litigation going on, and when it agreed to defend, its duty to defend lasts until there's some disposition of the case.
Thank you. I gave you a little leeway because
Thank you,
1
Your Honor.
minute was a little bit.
Thank you so much, Your Honor.
Yeah, maybe not quite enough. Yes.
Just really briefly, Your Honor, we're not saying that the complaint didn't allege property damage during the New York Marine policy period. What we're saying is plaintiff, and I cite to record citations at 104 and the verified bill of particulars and her depositions, because of these 3 distinct policy periods, everybody was trying to clarify, okay, what exactly are you seeking, damages? And she repeatedly said she was not seeking damages for anything that happened in our policy period because she was reimbursed for those damages, whether through her first-party homeowners, property insurer, or for a rent abatement. So that's our position. She's been fully compensated, so we don't have a duty to defend because we're not going to have a duty to indemnify. Thank you.
Thank you. Thank you both. Francis versus 4121 28th Street.
Good afternoon, Your Honors. I represent the appellants herein. The lower court ignored First Department precedent, case called Travelers versus Royal Insurance, and Second Department precedent, Superior Ice Rink versus Nescon, by, on this precise issue, holding that the language, the additional insured language in the Utica policy, was satisfied only if there was a written contract. This court has held the opposite, that the language at issue, which I point out in my brief, because it is ambiguous, is held to be ambiguous, and therefore, by my colleague in the motion court, simply saying that there was no written agreement did not fulfill the summary judgment obligation, and the lower court accepted the argument. My colleague is arguing it today, and it is flat out contradicted by 2 First Department precedent. If there are no questions, I'll yield the balance of my time.
Okay. Thank you.
Good afternoon, Your Honors. May it please the court. I'm Jonathan Glasser. I'm here from Lester Schwab, representing Utica National Assurance Company, the respondent. As the trial court, the Honorable Donald Miles correctly found, Utica is entitled to summary judgment dismissing appellant's third-party declaratory judgment complaint against Utica because appellants are not additional insureds on the Utica policy issued to MR Electrical. The general liability policy issued by Utica to MR has 3 endorsements, and all 3 endorsements require a written contract with MR Electrical and the purported additional insureds. It's a privity
It's your
requirement.
position that the contracts that were done were for service with one party and another, but were not contracts that specifically indicated that there was supposed to be insurance for that particular party as an additional insured. There was no individual contract that indicated that.
There was no contract at all
Right.
with the appellants. There were contracts between MR Electrical and other parties.
In fact, there were no you're right, there were no contracts at all between some parties, whether for service or otherwise.
No contracts at all with the appellants, that's right, Your Honor. There were contracts with Brooklyn GC and Queens GC, and that's not the subject of this dispute. The question is whether the appellants have a contract that entitles them to additional insured coverage under the Utica policy. And I'd like to get to the crux of it. The appellants argue that one of the endorsements on the policy is ambiguous and should be enforced in a way to allow for an oral contract, because there is no written contract. But the appellants don't actually work their way through the entire provision of the policy. The policy requires that any contract or agreement be executed. And for it to be executed, generally there should be a signature. Since there's no written contract, of course, there's no signature here. Now, there is some case law that provides that an oral contract can be executed by full performance. There hasn't been full performance here because the employee who was injured during the course of this hypothetical agreement. So full performance hadn't taken place yet, so it hasn't been executed. In the absence of an executed contract or agreement, there simply isn't anything that triggers an additional insured endorsement on the Utica policy. I mean, most interestingly here, appellants haven't even argued that there's a contract, even an oral contract. They're hanging their hats on this idea of ambiguity, but they haven't really thought it through. Also, finally, appellants could have argued this idea of an oral contract below, but they failed to do so. And arguments raised for the first time on appeal should generally be rejected by this court, particularly when they involve purportedly new questions of fact, such as whether there is an oral contract, which could have been the subject of discovery if they'd only been raised earlier. In sum, appellants are not additional insureds. In the absence of a written contract or agreement between MR Electrical and appellants executed before plaintiff was injured and requiring that MR Electrical procure insurance for them as additional insureds. And we simply don't have that.
Thank you.
If there are no further questions.
Thank you.
I'm done. Thank you.
A370, the record 254, my colleague kept using the word contract. There's three different ways. Written contract, comma, agreement, comma, or permit. He didn't say the word permit. He didn't say the word agreement. Those can be oral. This court has ruled that.
Counsel, this is Judge Scarpula. What evidence did you submit showing an oral contract?
My predecessor counsel who handled the lower court, Your Honor, I don't see anything in the record of proof of an oral contract. I do see the argument being made, however, at record 375. And on the summary judgment motion.
No. I mean, look, if you are saying that an oral contract would suffice, you've got to at least put up one piece of evidence to show that there might be an oral contract. And I've just asked you, did you put anything in? And you said no.
The answer is there is nothing in there showing the oral contract.
Thank you.
If I may finish, the last item is that on this summary judgment motion, on a coverage matter, additional insured, the obligation is on plaintiff to eliminate all possibilities of coverage under the policy. That wasn't done.
Thank you. Thank you both. People versus Ivan Edmonds.
Good afternoon, and may it please the court, Martin Asher, pro bono counsel from Kramer, Levin, Naftalis, and Frankel, along with the Legal Aid Society for Mr. Edmonds. This is a case about a father who has already served 3 years of probation and worked to get his life back on track after making one mistake. Mr. Edmonds was sentenced to a term of 4 years probation, which expires June 4th, 2022, and if his probation is reduced to the minimum 3 years, it will be over today. Mr. Edmonds' sentence to a probation term of 4 years is excessive in light of his lack of criminal record, acceptance of responsibility, and stable life situation. This court has the authority to reduce his sentence, and he is the type of person for whom courts have reduced excessive sentences, and continuing probation would hinder his ability to move forward with his life.
This was Mr. Edmonds' first arrest?
That's correct. It was his first and only offense.
How old was he at the time?
He was 28 at the time, and there were no prior convictions and no subsequent convictions either, Your Honor.
Did he have a family?
He does. He has 2 children, and he is now living with them, and he has been able to get a job as a marketing representative.
Was he supporting them then?
Yes, he was. He was paying $114 a month in child support, and took full responsibility for his actions and said during his pre-sentencing evaluation, "I apologize to the community and meant no harm in selling or distributing. I was just in a bad way," making it clear that this was a response to a desperate economic circumstance. But his pre-sentence report confirmed that it would be an isolated offense, saying that it appeared to be isolated, and his subsequent history has confirmed that thus far, Your Honor. By the time of his pre-sentencing evaluation in May 2018, he had already greatly stabilized his living situation. Unlike in August 2017, when he committed his offense while homeless and financially unable to support his children. As I mentioned, he was living by May 2018 with his fiancée and renting his apartment from a friend. If there's no further questions.
And so that was 2 years ago, 3 years ago.
About 3 years ago, Your Honor.
And right now, is he still stable now?
I was able to, we know that he has had no further offenses, and he has had no violations of the probation, and so we think he has gained the benefits of it, and is ready to get his life back on track. And if there's no further questions, I can rest on the brief.
Okay. Thank you, and thank Kramer Levin, your pro bono. Appreciate your time and assistance here on these matters. Thank you.
Thank you so much for your time.
Taylor versus New Jersey Transit.
May it please the court, Jessica Anderson on behalf of Appellant Defendant New Jersey Transit. If this court was to find that a lack of subject matter jurisdiction due to sovereign immunity needs to be raised before the filing of an answer, it would be the first court to do so. Such a decision would also be in direct conflict with the United States Supreme Court's decision in Rhaegar v. Regents, where the court stated that it has not adopted a rule which says a state's waiver of sovereign immunity or consent to suit could be inferred from the failure to raise the objection at the outset of the proceeding.
Counsel, when were these cases decided that you've relied upon here? Fitahu, I think it is, versus New Jersey Transit, and Belfand, no, the other one I'm looking at.
Yes, Your Honor. The court is correct that Belfand did come down earlier this year. I believe it was in June. However, this case is factually distinguishable from Belfand. In the Belfand case, the defendants had already tried the case to verdict, and they were picking the jury for their second jury trial when they raised the issue of sovereign immunity.
And what about the federal cases here that were decided? When were they decided?
I'm sorry, Your Honor, which case?
I'm sorry, franchise, for example, versus Hyatt.
Hyatt 3, Your Honor, was decided on May 13th, 2019.
Right. And then you had the other cases that were decided here. And when was this case brought?
I'm sorry, which case?
This case.
The procedural history for the case Taylor that we're here for today, the plaintiff filed a complaint on April 30th, 2019. Defendant appellant filed an answer on June 24th, 2019. Defendant appellant moved to dismiss based on lack of subject matter jurisdiction.
So these cases were filed, this case was filed after this United States Supreme Court case was decided, right?
The motion to dismiss was filed after Hyatt 3 was decided. That's correct.
But your answer was filed after Hyatt was decided, right?
That's right.
And even though you had how many defenses? 36 affirmative defenses, you never raised sovereign immunity.
It wasn't raised directly. However, our courts have previously found that sovereign immunity is a constitutional immunity that does not need to be pled in an answer.
Counsel, how do you explain the fact that you only made your motion to dismiss after the plaintiff's statute of limitations had run, similar to what happened in Belfand?
The statute of limitations issue, I think, is really putting the cart before the horse. Here, the court is...
How so, if some might view it as a litigation strategy?
I think it's putting the cart before the horse because here the court is really just deciding the very narrow issue as to whether or not sovereign immunity applies based on subject matter jurisdiction.
Counsel, there's a little bit more than that, right? I mean, the issue is whether you waived it by your litigation conduct. And here, what we have is you have 15 months of litigation. You asked for an extension of time. You provided an answer with combined notice of discovery, inspection, and deposition. You served bill of particulars. I mean, it's not like this is at its infancy. So when is enough for you to raise your issue? And it's curious to us that you raised your defense of sovereign immunity at a time where the plaintiff is now prejudiced because the statute has run.
Yes, Your Honor. So the majority of cases throughout the country say that sovereign immunity can be raised at any time because it's a matter of subject matter jurisdiction. A very narrow, limited amount of cases say that sovereign immunity cannot be raised after a court has submitted to a judge or a jury and an adverse result has followed. Here, this matter has never been submitted to a judge and a jury. There was not an adverse result, which makes it factually different from Belfand, where in Belfand, a jury had already made a determination on that case. Here, all that we have is an answer that's filed, little to no.
Again, the answer was filed on what date?
The answer was filed on June 24th, 2019. So really, this case is analogous to Rigor.
And then your motion,
The motion to dismiss was filed on July 10th, 2020. Even to date, no depositions have been taken. Very little.
So, counsel, if we use substantial reliance as a standard, what do you say about the plaintiff's loss of the ability to sue in the New Jersey courts if we were to follow your argument?
I think that that's really a decision that needs to be made by the New Jersey courts. They can obviously waive the statute of limitations if they feel that there's just reasons to do so, but I don't think
Did you offer that? I didn't see that in the papers. Did you say anything about the statute of limitations will be waived?
I did not say that.
You didn't do it in Belfand.
I'm not here today waiving the statute of limitations. What I am saying, though, is that the New Jersey judge who decides the statute of limitations issue can decide for just reasons to waive it. But I think the issue with that is that's really a decision that would be made by the New Jersey courts. The decision that's only here before us today is whether or not sovereign immunity applies.
So I have to just ask again. So the federal case that held that under the doctrine of sovereign immunity, a state can only be subjected to private suits in the court of a sister state if it consents clearly, right, was decided in 2019. This case was brought June of 2019. Months went by. You had to know about that case. You had to know about the federal case. You did all these affirmative defenses, but never this one. I'm just not sure, given the presence of the decision in the United States Supreme Court, why your office didn't feel that it should say anything, do anything. What was transpiring? You were not aware of the case? You were just not aware of the case?
Your Honor, again, sovereign immunity does not.
No. I asked you, were you not aware of the case? Your office just wasn't aware of the case, the Supreme Court case.
At the time that we filed the answer?
At any time from the time you filed the answer, which was after, it was in June, from the time you filed the answer till when you put in your motion to dismiss. I mean, at what point did you become aware of the Supreme Court case?
I can't say for certainty of the exact date, but during this time we were also.
I mean, your office this is an important issue to your office, to every office in the country, it would seem to me, that represents a state. So I can't imagine that your office was not aware that this important Supreme Court case that affected sovereign immunity had come down. I don't understand that your office was just not aware of it at all. Is that what you're saying?
At the time that the answer was filed, we were not.
And so how long did it take you before you were aware that this important Supreme Court case had been decided? Just a month before you even filed the answer.
That date I don't have.
Okay, well, you can think about it while counsel argues.
Okay, thank you, Your Honors.
May it please the court, Frank Deldone for a plaintiff respondent, Robin Taylor.
Counsel,
yes,
your
Your
opposing counsel argues that sovereign immunity can be raised at any time, and technically she's right. Why shouldn't we find?
Well, the United States Supreme Court didn't rule that way in Lapidus versus Board of Regents of Georgia State University. And what happened there was when the defendant invokes the jurisdiction of the court, they're consenting to the jurisdiction of the court, and therefore they're waiving their sovereign immunity by their litigation conduct. They did the same thing here. In this case, they filed an answer without any affirmative defense for sovereign immunity, and they also filed cross claims against the defendants for contribution percentages for a determination on the liability percentages among the defendants, and they also filed a breach of contract claim against one of the other defendants.
Counsel, are you saying that you're saying that you can't raise sovereign immunity at any time in a litigation? Is that your position?
No, my position is under Belfan that they waived their sovereign immunity by their litigation conduct. And also, when they filed cross claims against the other defendants for determinations on the liability percentages, a determination from the New York Supreme Court for liability percentages, and this is a personal injury case, they filed a breach of contract claim, which was not raised in plaintiff's complaint. They filed a breach of contract claim against one of the other defendants. Therefore, they invoked the jurisdiction of the New York Supreme Court by filing a claim really not in the four corners of plaintiff's complaint. So they chose the jurisdiction of New York Supreme Court with their answer, and that's at pages 46 through 48 of the record. They filed cross claims and they filed a breach of contract claim against another defendant. So they chose the forum, and that litigation conduct under Belfand and under the United States Supreme Court, Lapades versus Board of Regents of Georgia, specifically says when you invoke the jurisdiction of the court, you are waiving your sovereign immunity. You can't have it both ways. You can't say, well, they have jurisdiction, we have jurisdiction here to decide these claims, and then there's no jurisdiction here to decide those claims. Lapades was very specific that if they can raise the claim, each claim in the same case, it would result in unfair results and would prejudice the plaintiff. They did the same thing here. They chose the New York forum for their cross claims, including their breach of contract claim against the other defendant, and therefore, New York Supreme Court, they voluntarily invoked the jurisdiction of that court. They cannot now claim sovereign immunity based on that litigation conduct. That Lapades case is clear on that, and that was decided in 2002. In addition, because this case came down, the New York Supreme Court cases at the time, this case and some of the other cases that are coming up were decided. The New Jersey Tort Claims Act was deemed the waiver. Belfand changed that and said, no, the New Jersey Tort Claims Act is not the waiver, so that's out now. In the lower court, there was never a determination as to whether or not New Jersey Transit is actually an arm of the state either. New Jersey Transit relies on a Third Circuit case. Okay, we're in the Second Circuit here. It's a completely different test. So there's no determination in the Supreme Court to determine whether or not they're an arm of the state for sovereign immunity to even apply. They just specifically...
Did you raise that below, counsel?
No. What happened was in Belfand,
okay.
in Belfand it was conceded. In Belfand, the plaintiff conceded that they were an arm of the state. In the lower court, New Jersey Transit relied on the Third Circuit case, but the court never made a determination as to whether or not they're an arm of the state. The Second Circuit and all the circuits are very clear. It's the movement's burden to establish the sovereign immunity claim, and they used the wrong test in the lower court, and they used the wrong test here. They use a Third Circuit case. The case in the Second Circuit is Woods versus Roundout, 466 F. 3rd 232, Second Circuit 2006, and that's the applicable standard. So there's no determination that New Jersey Transit is an arm of the state, and we never conceded that point. It's never really been briefed. It was never decided in the lower court, and it wasn't raised in the briefs here. But it's their burden to prove that on their motion, and I think the cases are clear on that. And there's one more thing. There's a case coming down on that, Jeffrey Colt versus New Jersey Transit. I just found out about this. It's scheduled for the December term 2021 here as to whether or not New Jersey Transit is actually an arm of the state. So I'm letting the court and my adversary know that that case is coming too and will be argued here in December of 2021.
Well, shouldn't we let New Jersey decide that?
Whether they're an arm of the state?
Right. How is New York going to decide that?
Well, it has its own test called the Mancuso test. So Woods lays that out very clearly. The Second Circuit, it's the Mancuso test. Generally, the most...
So what happens if New York says yes and New Jersey says no?
Well, it's a matter of federal law. Whether or not a municipal entity or whatever entity is an arm of the state, and whether 11th Amendment immunity applies is a question of federal law.
That's not before us today.
So
Right.
it's really not brief, but I'm letting the court know it's coming.
Thank you.
It's coming in December of 2021.
Thank you. Counsel?
I would just like to address my adversary's argument about the Lapidus case. That case is also factually distinguishable from this case. In the Lapidus case, the state removed the case to federal court and then immediately moved, saying that they're immune from liability under the 11th Amendment. That's not what we have here. Here, New Jersey Transit was involuntarily brought into court. It's a much different standard, and the reasoning behind it is much different than Lapidus. Thank you, Your Honor.
Thank you. Thank you both. Oberon versus Titanic Entertainment Holdings.
Good afternoon. May it please the court. My name is Jeff Wasserman, and I am here on behalf of the 4 defendant appellants. We moved to dismiss the complaint, the amended complaint below, and the court granted the motion except to the extent that it allowed the first cause of action to proceed for breach of contract. Oberon and the first named defendant, Titanic Entertainment Holdings, LLC, executed an agreement in July of 2017 whereby Titanic Holdings, the first defendant, engaged Oberon to act as its consultant and exclusive financial advisor.
So we know the facts.
So,
and we understand that the rub came here where when Oberon found a company that would do the financing and wanted a success fee, and I believe your client didn't feel that that was part of the original contract, and they at that point stopped paying under the original contract, right? Why don't you take it from there?
Sure. Well, Your Honor, there's a few separate issues embedded in that. Where I was headed was that we concede that Titanic Holdings, the signatory to the agreement, is bound by the agreement, however that comes out. The other 3 defendants, however, did not sign the agreement. There was no place for them to sign the agreement.
Yeah, but they were all one entity.
They were not.
I mean, counsel said, I'm sorry, your client seemed to indicate that in the very beginning.
Well, Your Honor, there are 4 distinct corporate entities. They have separate existences. The party to the contract, defined as the client, is the first entity. The agreement itself refers to a broader category called the company, which is sort of a catch-all, but just because the agreement's terms might apply to a transaction done by the broad company does not make non-signatories to the agreement bound to it. Titanic Holdings, Entertainment Holdings, the first defendant, is bound. The other 3 did not sign the agreement. The agreement does not purport to be signed on their behalf.
I think, isn't it the case that almost all of the writings relating to defendants refer to Titanic Holdings, Cedar Bay, Titanic Tennessee as the company, right? And then Jocelyn himself described Allen Entertainment as the new umbrella LLC. And then I don't know that there's any documentary evidence to contradict any of those representations that were repeated throughout.
Well, those representations were not, they're not, let me restate that. Titanic Holdings would be liable for a transaction done by the entities that fall within the definition of company. We're not disputing that. What we're saying is that the other 3 entities, quite simply,
which 3 specifically?
The other 3 defendants, Titanic Tennessee, Cedar Bay Entertainment, and Allen Entertainment Holdings.
Right. And so,
I don't want to interrupt you.
No, go ahead.
They did not sign the agreement. The agreement was not signed on their specific behalf. The agreement was not signed with a representation.
Right, so okay, so they all did that. They all referred to as the company. Those three were referred to as the company. And then, as I said, Jocelyn described that Allen Entertainment as the new umbrella CCC, LLC. And I think the motion court raised the fact that Titanic Holdings dissolved during the terms of the agreement. And there would be no one, they dissolved.
Your Honor,
So
sorry.
what does it mean that Jocelyn described himself, Allen Entertainment, as the new umbrella LLC?
Well, Your Honor, the agreement, just to make clear, the agreement itself says that the other entities, any within the company or otherwise, need to agree in writing to be bound by the terms of the agreement. That language would not exist in this agreement if the other entities were bound by it.
Even given the fact that they use the word that they use the word company to refer to all three of them, doesn't it make it foreseeable then that they'd be subject to the jurisdiction of in New York, given that they referred to themselves as company?
Well, the term company was a defined term in the agreement. It wasn't otherwise. And how it's referred to in the term of the agreement, the way the term company is defined, and it's broad, still doesn't make non-parties to an agreement bound by it. There were ways to bind them. The parties did not do them. And there's a question, and I hear it, and I understand it.
So counsel, isn't this a triable issue of fact?
Well, Your Honor, I think the contract speaks for itself in that three of these parties did not sign it, and there's a merger clause, sections 11.1 and 2 on record page 77, that would preclude external evidence to determine whether they're parties. They are not parties. That's clear because they didn't sign the document, and it wasn't represented to be signed on their behalf. If you look at the signature...
The definition of company is encompassed within the agreement, right?
But the company didn't sign the agreement. The agreement was signed...
And Mr. Jocelyn is the controlling member. Well,
so if the plaintiff is... That's language of piercing the corporate veil. That's not language of binding as a direct party, these other three defendants to the contract. Your Honor, the signature page itself, R78, says it's agreed to and accepted as of the above date by Titanic Entertainment Holdings, LLC, by its president, John Jocelyn. It doesn't say it's that anyone else agreed to this contract. And I understand the arguments why plaintiff wants to broaden it, but they did not agree to be bound and shouldn't be found to be bound. And as parties who didn't agree, there's no allegations of personal jurisdiction over those defendants here. I see my time is up. I have a point or two that I'll make in rebuttal if that suits the court.
Okay.
May it please the court, Robert Knutz for the plaintiff respondent Oberon Securities, LLC. In the record before the lower court, and one reason why the lower court denied the motion to dismiss is, and why she found that Titanic Holdings signed it as agent for the other defendants, it's at page 92 of the record. There's a board minutes where Titanic Holdings is specifically identified as a company that was created to act as an agent for Cedar Bay and Titanic, Tennessee, to raise money by hiring an investment banking firm. So this notion that, you can just put Titanic Holdings aside and ignore what was in the record, that's a factual issue relating to the case. It's why the lower court denied the motion to dismiss, because Justice Masley concluded she couldn't, in fact, ignore the allegations in the complaint that Titanic Holdings signed this engagement agreement as an agent, for Cedar Bay and Titanic, Tennessee. And then when you add to that the fact that while the engagement was ongoing, Mr. Jocelyn secretly dissolves Titanic Entertainment Holdings and then continues to make payments under the agreement through the Cedar Bay account. There is no way that on a motion to dismiss that either the lower court or respectfully this court can ignore the allegations that as an agent, Titanic Holdings could enter into the agreement and bind these other parties, to the terms of the agreement. So I think that that just is part of the factual issues that caused the lower court to deny the motion to dismiss. One of the, defendant's counsel vigorously argues that my client did not introduce the contracting party to the defendants. But we specifically alleged that we did. We did, in fact, say you should go do a deal with this entity. This should be the kind of deal it was. And we put in a supporting affidavit to further flesh that out. And it's just not appropriate.
And counsel?
Yes.
Counsel, and your argument, of course, is that agency is different from piercing the corporate veil. You're not trying to pierce the corporate veil. You're saying that one party executed the agreement as an agent, either disclosed or non-disclosed, we can figure that out, for the other. That's a different argument, correct?
100% correct. And it's supported by the documentation in the record. So if your honors have any more questions, I'll be happy to take them, but otherwise I'll rest.
Thank you.
Thank you. Very quickly, and just to emphasize the point, this contract was not signed on behalf of the other entities by an agent. It does not say Titanic Holdings as agent for these other defendants. It would say that, it could have said that, and it should have said that if they wanted other parties to be bound by it.
Okay, but counsel, that's the allegation, and there is some backup for it in the record.
But Your Honor, this is a contract with a signature page and a merger clause. The allegation is what it is. The document is not signed by these other three parties, and it's not signed on their behalf. It's not written as if it's on their behalf. It's not represented in the agreement that it's on their behalf. All it says is that these parties fall within the types of entities that if they did a transaction, it would be Titanic Holdings' responsibilities.
What about, counsel, what about the minutes of the board meeting that says the party that did sign the agreement was created as an agent?
The board minutes from a year later, but Your Honor, I just wanted to make one other point about the Morpheus case.
I mean, maybe at the end of the day, on summary judgment, you might prevail, but the question is, has enough been put up on a pre-answer motion to dismiss?
My point, obviously, is that the contract itself speaks for who it governs. But, Your Honor, there was an issue with the Morpheus case. The Morpheus decision of the Court of Appeals sets out an exclusive agency, exclusive right to sell dichotomy. It plainly applies here, including based on language within Morpheus and within this court's own decision in Alta Capital. And this contract, whomever it's binding against, is an exclusive right to sell. And as such, whatever the allegations were about the transaction, which don't fall within the defined terms, we lost sight of that here, Your Honors. The sale-leaseback transaction that is alleged very clearly does not fall within the types of transactions in section 4.1 and 4.3 that lead to a success fee in any event. So, leaving aside who the parties are, the alleged transaction doesn't fall within the agreement anyway, and that's apparent just by reading the definitions. And beyond that, to the extent that it would apply, I think it's important that the court appreciate that in this case, the Morpheus case governs and that it is an exclusive right to sell, and I think the court would need to be clear in a decision on that. Thank you. Unless the court has any questions, I'll submit.
Thank you.
Thank you.
People versus John Robinson.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant John Robinson. May it please the Court. I'd like to address primarily the issue of sentencing this afternoon, but first I do want to address the weight of the evidence point. My client was convicted of possession with intent to sell a single zip of crack cocaine. He had only $32 in his pocket when he was arrested.
Not usually the facts one sees for someone selling.
Correct. And the only evidence that there was an intent to sell was testimony from an officer about a prior transaction he claimed to have observed from a vantage point late at night in Sheridan Square in the Village. The people introduced photographs taken during the daytime from that vantage point, and I believe that they show that he could not have seen what he says he saw. And more than that, there's nothing really I can say. I can just urge you to look at those.
He said he had high-definition binoculars.
He did have high-definition binoculars.
He said his ability to see was better than the person who actually took the photograph.
Well, that's what he said, Your Honor. And he also said that he saw the transaction. And I think the court should look at that very skeptically. The photos that were taken in the daytime, he was, 1 a.m. in the morning. The photos were taken at the daytime. I can't conceive of how he says he saw currency handed back and forth halfway down the steps to these subways. Those photos have been uploaded, and I just ask the court to look at them. I don't think it supports that officer's claim, and that was the only evidence that there was an intent to sell, the single zip that he had. $32 certainly didn't show an intent to sell, that he was involved in any repeated transactions. And I'm just turning to the issue of sentence. The people, these are two convictions. One was this single zip of crack. The second was a $100 sale of crack to an undercover. These occurred in 2012 and 2013. My client is still incarcerated. He's more than 2 years away from release. 10 years for these street-level sales is just a draconian and unwarranted sentence. The people were willing to resolve one of the offenses pre-trial with a 1-year jail term. That kind of puts into context what they thought before my client went to trial was an appropriate sentence.
Which one was that?
That was the 2012 intent to sell charge, which also had a sale charge with it, but my client was found not guilty of that, so that included a sale charge when the 1-year jail term was offered. 10 years just makes no sense to me. The 6-year minimum was based upon the fact that my client had a prior violent that he committed when he was 19 years old.
And how old was he at this time?
When he committed the offenses in 2012, he was 35, so 9 years to that, he's 44.
And the original, where he got the other offense, he was 19 years old, you said?
That's correct, when he committed the robbery offense. So that raised the minimum sentence that he could have received to 6 years, which it seems incredibly harsh to me as a starting point. But nothing warranted really more than that 6-year sentence. Yes, it was 2 transactions, but that 6 years.
He had already served a sentence when he was 19. What was that?
I don't remember. I don't have.
But whatever it was, he served that sentence.
He had served the sentence, and there's that 10-year tolling period, and he was within a year of reaching that 10-year tolling period.
So had it been another year, that wouldn't have been included.
That wouldn't have been. He wouldn't have had a 6-year. It would have been like a 2-year minimum that he would have faced, and just a 10-year sentence is just too much under the circumstances. Thank you.
Thank you.
Good afternoon. Nathan Scher for the people. May it please the court. Your Honors, the jury's verdict as to the 2012 indictment comported with the weight of the evidence in this case. as there was ample evidence that defendant had intended to sell the drugs that were found on him.
It does boggle the mind a little bit how an officer with binoculars late at night could say he can see better than a daytime photographer taking a photograph, but that's what the jury found.
Well, Your Honor, I would note that there's testimony that the area was very well lit, and I don't...
Better than daylight, apparently.
I'm sorry?
Better than daylight, apparently.
I would say that I don't believe that there was necessarily testimony that he could see better in terms of versus the photographs. I think what he was mostly trying to say is that his vantage point was higher, and therefore he had a different angle looking down into the subway stairs. There was testimony that he was much taller than the photographer who took the photos, and so he had a better vantage point. And so he was able to see defendant hand a small object to the other man, Padelaford, who in return...
And identify from that distance specifically what the object was.
No, Your Honor. He did not testify that he could see that it was a zip of...
I think he said he saw money. I think he said he saw the money.
Yes, he said that he saw a defendant pass a small object to Padelaford, and in return, Padelaford handed cash to defendant. And so that observation, coupled with Officer Susanna's prior observations, the hour prior to that transaction.
Well, getting to that, the hour prior to that transaction, the officer only testified that he saw several transactions, but he didn't remember how many. And isn't that sort of belied by the fact that the defendant, when he was arrested, only had one Ziploc and $32? How can that possibly be? If there were several transactions, how can he only have $32 when he's arrested?
Well, Your Honor, Officer Susanna did not testify that he saw several transactions take place. What he did testify to was that he saw defendant walk around Sheridan Square, approach passersby, gesture at them to follow him, leave the area, and then return alone. Whether or not there were successful sales made or just attempts at making sales, that's not really the point. The point is that Officer Susanna watched what he believed were attempted sales or conduct that resembled that of someone dealing drugs. And as to the $32, there was testimony from a Sergeant Abbott, I believe, that stated that the price of crack cocaine in that area at that time was $10, and therefore $32.
Oh, he only made 2 sales? He only had $2 on his person prior? He only made 2 sales?
I don't think it's out of the question that someone could only make X amount of...
I don't think it's out of the question either, except that the officer suggests through his testimony that he saw several transactions, not just 2. So that's where the question comes.
And I totally understand, Your Honor. I don't know. I see that the light is on.
Just, counsel, just to refresh, I have part of the transcript here. It says, this is part of cross-examination. Do you know how many different interactions he had while you were observing him? Answer, I don't know the exact number. There were several, though.
Yes, Your Honor.
Well, you just said he didn't say several, that he said 1.
But, no, Your Honor, what I meant is that he didn't see, I believe the way you had phrased it was that he had made several transactions. And I'm saying that he didn't see those transactions take place because those defendant with those individuals walked out of the view of the observation.
Okay, and I have one more question to ask. I know that your time is up, but I have to ask this. On the 2013 indictment, that case, he pled guilty to criminal sale of a controlled substance in the 3rd degree and criminal possession of a controlled substance in the 3rd degree. This court vacated the plea to criminal possession of a controlled substance in the 3rd degree, and originally the defendant had been sentenced to 7 years. After we vacate, he's sentenced to 10 years. How did that happen?
Well, I think the point to make is that those 2 prior convictions before they came up to this court. Those sentences were to run consecutive to one another, and so defendant was to be imprisoned for 14 years.
So the goal was to imprison him for 14 years, as opposed to sentence him individually on these two indictments.
I apologize, Your Honor. But my point is these sentences are to run consecutive to one another, and so it is a 10-year sentence under the 2013 indictment, but that is running consecutive to his 6-year sentence.
I understand that, but it boggles the mind that in this indictment alone, after we dismiss one count, after we vacate one count, that the lower court would then increase the penalty by 3 years.
Well, Your Honor, I think in its actual effect, the amount of prison time he will be serving has decreased since
In the aggregate, you're correct. But I'm focusing on this one case, on this one indictment.
Well, Your Honor, I think that there were aggravating factors in that case.
That existed before we vacated.
That's correct.
Okay.
Counsel, how is it that he faces, what's the range here?
On both of these Class B felonies, there's a minimum of 6 years and a maximum of 15 years.
And he's a predicate?
Yes, I believe he is a second felony offender convicted of a prior, second felony drug offender convicted of a prior violent felony offense.
And when was that violent felony offense?
Your Honor, I'm not completely sure off the
Well,
top.
can we take counsel, an officer of the court, that he said it was when he was 19?
I would.
And that usually we don't look at that if it's beyond 10 years, and that this was 9 years?
That sounds correct, Your Honor, but.
So that if it was one more year, his sentence would have been a minimum of something like 2 or something like that, because it wouldn't have been taken into consideration. Is that right?
Again, I don't know the exact number off the top of my head, but I presume.
Well, let's assume all of that is correct. So that because of that 1 year, and I understand it's 1 year, we didn't reach the 10 years, but he gets, he's sentenced to 10 years, not just the minimum, not the 6 years, but 10 years. Would it be unfair to reduce this to 6 years?
Your Honor, I just believe because of the aggregating factors in this case where defendant had committed this crime as to the 2013 indictment while out on bail for the coupled crime, the 2012 indictment.
These drug offenses that we're talking about here?
Yes, Your Honor. He committed it while he was out on bail, and they were, again, both.
The one with the $32 in his pocket, that one we're talking about, right? That's one of them.
Yes, yes, Your Honor.
Okay.
If there are no more questions, we just ask that you affirm.
Thank you.
Thank you.
Just one quick comment about the officer's ability to see from his vantage point. Those photos were taken from the same second floor as the officer was located. The photographer was standing on the same radiator that the officer was standing on. So maybe there was a 3 or 4 inch difference 20 feet off the ground from their vantage points. But I'm not an expert at geometry, but I don't think that would provide any difference in their ability to see from that second floor on top of the radiator into a subway stairway at night. That the vantage point, the differences in their heights could not have made a meaningful difference in what they could see.
Thank you. Thank you both. Camara versus New York City Taxi and Limousine.
Good afternoon, Your Honors. My name is Dan Ackman. I'm here for the appellant, Mr. Camara. First of all, I have a...
I want to ask you right
Sure.
off why this is not moot.
It's not moot for 2 reasons. One is that there's a damages claim for incidental damages, And secondly, I actually have a notice of additional citations which speak to that. And there are there was a Court of Appeals case.
But he was already reinstated, so it's not this, I don't know what we would append the damages to. And he was properly suspended.
No, he was not properly suspended, Judge. To answer the mootness question, the case of Matter of Hearst versus Klein states quite clearly that there's an exception to mootness when there is a good chance of repetition yet evading review. That's exactly what's happening in this case. This kind of act by the TLC happens more than 1,000 times a year, so there's certainly a good chance of repetition, even as to this individual, but certainly as to the community of drivers at large. And yet it will evade review because very few of these suspensions last long enough even for a case to be litigated in the trial court, let alone to reach this court. So there's really no way to litigate this issue without this mootness exception. That's why this mootness exception applies perfectly to this case.
So, counsel, you're saying that you can litigate the issue of damages only in Article 78, where the primary issue is decided?
No, I'm saying you can litigate the issue of damages in Article 78. I suppose you could do it elsewhere as well, but it's
in
not
a plenary action, right?
Right. But either way, it's not moot because of the capable of repetition yet evading review standard announced in the Matter of Hearst case, which is 50 New York 2nd, 707, 1980, Court of Appeals.
But the issues here are not novel, and in those issues, it's usually where it presents, substantial and novel issues. There's nothing novel about this issue.
Well, it is novel.
Not likely to evade review since the TLC summarily suspends numerous licenses.
Right, but it's novel in litigation in the Supreme Court or this court. There's been no other litigation of this issue in court, even though it happened, the suspensions happen often.
You might want to focus on another issue. You don't have much time left.
Okay, I'll focus on the main issue then. This suspension occurred despite the fact that it was a misdemeanor charge. Mr. Kamara was released on his own recognizance. He had an excellent driving record and no criminal record. Yet the TLC suspended him without any kind of investigation whatsoever. That's the essence of arbitrary and capricious. It's the essence of irrational, and the irrationality applies to the entire program. And it's the essence of a violation of law or inconsistent with law, because the only statutory basis for the suspension requires that the driver be a direct and substantial threat to public safety. And there's no evidence that he was. There's even no allegation that he was. And there's also no evidence in the historical record that drivers who commit or who are alleged to have committed crimes and are arrested are therefore a threat to the public. An arrest doesn't require that finding, and there's no finding the TLC has ever made or attempted to make that drivers who are arrested therefore are likely to threaten or harm a passenger.
But counsel, the assault 3 charge is one of the listed charges in the statute.
No, it's not the statute, Judge. That's the key thing. There is no statute.
Administrative Code 68-15D?
That's not a statute.
Well, I misspoke. It's a regulation, it's a rule, but that certainly supports a summary suspension. Assault 3 is one of the listed charges.
Yes, the suspension was consistent with the rule, but the rule is inconsistent with the statute, which doesn't mention arrest, does not permit suspension on arrest, only permits suspension on a finding of good cause the drivers are direct and substantial threat to public safety. And my point is that an arrest doesn't show that. An arrest does not require that finding. The arresting officer doesn't make that finding. And so there's nothing in the record that makes him a direct and substantial threat to public safety unless you can infer from the mere arrest that he is that, and there's nothing in the historical record that suggests that is the case. There's nothing in this record, just the record of Mr. Kamara's case, that suggests that is the case. There's nothing, there's no evidence in this record that suggests that the suspension was consistent with the statute. That's why it's inconsistent with law, and because it's So, and because there's never been any evidence or finding by the TLC that someone is arrested is therefore a threat to public safety, is arbitrary and capricious and irrational.
Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon. I'll start with the same question I asked your co-counsel. Is this moot? Is this issue moot?
Yes, Your Honor, this case is moot because Kamara received all the relief that he is entitled to here. Kamara's petition asked for an order reinstating his license and asked that the suspension be declared void. Kamara's license was reinstated by TLC. He's been free to drive for Uber or Lyft for the past 10 months. And his claim that this case is not moot because he has also made a request for damages is simply not true. The only damages that can be recovered in an Article 78 proceeding are incidental damages. These are not incidental damages. These are
What about the exceptions to the mootness doctrine that he discusses?
So the exception here does not apply either. As Your Honor noted, first of all, this is not a substantial or novel question. It's an ordinary construction of a city regulation, and it's also not an issue that's going to evade review. And this case proves that. Shortly after Kamara was summarily suspended, he brought an Article 78 proceeding, filed a motion for a TRO and a preliminary injunction, and got a ruling on the TRO before the administrative law judge ever ruled on the suspension hearing itself. So anytime any other driver in the future comes and gets summarily suspended and wants to challenge that, they have that procedural avenue via an Article 78 proceeding. And then one more point, Your Honor, this case is independently subject to dismissal on subject matter jurisdiction grounds because this summary suspension is not a final agency action. And again, that's proven by what actually happened here. The summary suspension, the effect of it could be significantly ameliorated by subsequent agency action and steps available to Mr. Kamara. And Mr. Kamara took those steps. He asked for a suspension hearing, he received the suspension hearing, the ALJ ruled in his favor, and then TLC agreed. So he got everything that he wanted, and the summary suspension itself was not a final agency action.
Counsel, what do you say to opposing counsel's argument that the administrative code that appears to support suspension for an assault charge is inconsistent with the statute that requires substantial threat, a direct and substantial threat to public health and safety?
Sure, Your Honor. So the statute that Kamara is referring to says that TLC can order a summary suspension when there is a showing of good cause relating to a direct and substantial threat to public health or safety. It doesn't require irrefutable proof that there is a certain direct and substantial threat, and it doesn't define what constitutes a direct and substantial threat to public safety. So the City Council gave TLC some latitude to use its regulatory authority to define direct and substantial threat in the way that it saw fit, and it did so by passing a rule that listed certain specific types of crimes that satisfy the direct and substantial threat requirement. And they focused very specifically on crimes related to violence, sexual assault, and driving specific crimes like driving under the influence.
And counsel, in this case, just to be sure, the driver had been arrested for an allegation of domestic violence. Is that right?
That's correct, Your Honor. He was arrested for third-degree assault and another crime that's not at issue here. If there are no further questions, the city asks the court to either dismiss the appeal or affirm. Thank you, Your Honors.
Okay, thank you.
Your Honors, I'd like to briefly address finality. In this case, the suspension was ordered and put into effect. There was nothing preliminary about it. There was nothing uncertain about it. The TLC suspended Mr. Kamara and said, and he could not drive as of that moment. That was a final action by the TLC. The suggestion that it's not final because there could be a decision as to whether the suspension would be extended says nothing about whether the summary suspension was final. All the administrative action did is determine whether it would be suspended further. It did not erase the original suspension, so it was as final as it could be. As to mootness, counsel said it's not substantial and not novel. Well, it is substantial because as it's conceded that the TLC suspends more than 1,000 drivers per year. That makes it a substantial point affecting many, many drivers, not just Mr. Kamara. I submit that if that doesn't make it something substantial, nothing will. And it is novel because it's never been litigated in this court or in the trial courts.
Thank you.
Thank you.
Thank you both. Hernandez versus 767 Fifth Partners.
Good afternoon, Your Honors. May it please the court. Glenn Devora for the plaintiff appellant. This is a straightforward labor law 240 case. Plaintiff fell through a scaffold. The bottom of the scaffold, like a trap door, gave out.
And there were no witnesses, only your client.
Correct. No known witnesses other than my client, and there's no evidence to contradict my client's version of what happened. To the contrary, there's evidence that the defendant's own witness came to the scene shortly after the accident and confirmed that the floor of the baker was sitting underneath the top of the baker, which is exactly what the plaintiff described happened. The lower court initially granted plaintiff's motion for summary judgment.
Yes, we know that.
And it made it up through the appellate process quicker than this case, and the court has recently issued a decision in May of 2021 on this very matter, and they confirmed the lower court's granting of plaintiff getting summary judgment. So we find ourselves in an odd position here where the motion to re-argue that I'm appealing has already been decided by this court, and this court has already said that the original decision granting summary judgment was the correct one. To the extent the court needs it, the site of that case is 194 AD 3rd, 649, Hernandez verse 767. So to the extent this matter, we believe, has already been decided in our favor, the lower court's ruling with regard to the re-argument, which is what we are appealing today, should be reversed.
Thank you very much.
Thank you.
NASA versus 1512 LLC.
May it please the court. My name is Fern Flomenhaft. I represent the defendants, appellants 1512 LLC and Howard Plotkin. The trial court should have set aside the verdict and directed judgment in favor of the defendants. There simply was no evidence to support the verdict. No valid line of reasoning from the evidence presented could have led to a verdict in favor of the plaintiff in this case. Though the plaintiff claimed the condition, the uneven condition, otherwise known as a door saddle, was the cause of his accident, there is no proof of a defective condition, no measurement, no expert, no standard, no evidence or testimony of what about the allegedly defective door saddle caused the plaintiff to fall, or even how he fell. As to lighting, the plaintiff merely stated it was dark. As a matter of law, that is insufficient to establish inadequate lighting. He said, I fell because of an uneven condition. That was the entirety of his testimony.
Counsel, you're phrasing it as a door saddle.
Yes.
Was that conceded by the petitioner in this action?
It was not conceded. The petitioner, the plaintiff, made a strategic decision to call the condition an uneven, misleveled condition, and he refused to concede that it was a door saddle.
Well, the jury had several photographs that I saw that were contained in the record of what you're calling a door saddle, correct?
I'm sorry.
The jury had photographs of what the plaintiff called an uneven condition and what you're calling a saddle, correct?
Correct. The jury had a few photographs of the doorway where the plaintiff said he fell. And it was, he he had no knowledge of whether it was a door saddle, but he called it an uneven condition. My client, Mr. Plotkin, and his superintendent, who have been at the building for, I think, 30 years, testified that it's a door saddle. It's always been a door saddle. It serves as a door saddle. It operates as a door saddle. It does what a door saddle is supposed to be. It's no more than a 1/4 inch high. And the decision to call it an uneven condition was really a burden-shifting, strategic decision. It should not have been my client's burden to prove that the door saddle was a door saddle. In essence, they were calling it a defective condition. I mean, the same thing could be said of a stairway. If you call it a
But counsel, two of your witnesses also testified that this was, whatever you call it, it was raised at least a 1/4 inch off the ground,
A
right?
door set, it was raised no more than a 1/4 inch, and a door saddle is by definition raised. And there's many cases that we cited that a door saddle of a 1/4 inch is trivial, particularly, Hall versus, well, there's several cases, but in Hall versus New Way Remodeling, this court rejected the plaintiff expert, stating the expert's assertion that a person could stumble over the saddle is not enough. You can't just say that. And in this case, they had no expert, and only the plaintiff counsel in his summation said that. So here there was just no evidence of a defect
But
and no.
counsel, going to the issue of the photographs,
Yeah.
the saddle, quote unquote, viewed from different positions could be viewed differently by the jury, right?
The jury
The
had
jury
yes.
The jury had the opportunity to look at those photographs. Everybody is familiar with the door saddle. It's within the jury's ken. So irrespective of what the saddle was called, the jury could have decided it was a saddle, it wasn't a saddle. I don't know that that was a specific question on the verdict sheet, but if you felt that this was not a matter within the expertise of a jury, you were free to call an expert, right?
Yes, Justice Gonzalez, we were. Let me just address the photograph in response to your question. The photograph was a photograph. Whether it was a door saddle or a raised condition of no more than a 1/4 inch, it was what was represented in the photograph is a worn old condition. There was nothing about the picture that showed it was a tripping hazard. A picture doesn't speak. It certainly could not speak to how the plaintiff allegedly fell over this condition of no more than a 1/4 inch. There were no measurements provided. There's no evidence of crumbling, of loose conditions, no measurements of the height other than Mr. Plotkin's testimony.
But counsel, couldn't your superintendent have provided measurements?
Well, actually, no. Your Honor, the court would not allow my clients to provide measurements. What she allowed was for them to estimate. And since he knew the measurements, the superintendent did say that it was a 1/4 inch at its highest. So both Mr. Plotkin and Mr. Nunez provided measurements. They just weren't allowed to say that they measured it, even though they did, but they weren't allowed to say that because that was the court's ruling. I'd just like to move to the admissions.
I'll let you do that on rebuttal, okay? Because your time is up.
Okay.
May it please the court, Alex Walwick for the plaintiff respondent. Your Honors, I'm not sure why we're discussing or using the word strategy here. The condition is what it is, and the photographs show what the condition was. Whether you want to call it a saddle, which is what the defendants insisted on calling it, or whether the plaintiff called it a defective condition, or whether the plaintiff said it was an uneven surface, uneven condition, I'm not sure what the point of using strategy to present it to the jury has to do with anything. Again, the condition is clear from the photographs, and it is what it is. It shows a hard, uneven surface, a sharp edge. The plaintiff testified that there were no lights on in the vestibule. The plaintiff testified that the weather outside was dark and cloudy and overcast. And you look at the photographs, which the jury could also do, you can see that, and the door was open, and it almost looks like, and this is what the jury could infer, that you can see the uneven surface, and I think they could decide for themselves that it's not merely a 1/4 inch, it might be even higher. that it kind of confusing from where the so-called saddle ends and where the rest of the step continues. And the jury can infer that it's pretty easy to get confused with the door open and just sort of not realize that there's this uneven condition and trip on it. The plaintiff said that in answer to questions that he stumbled on it, that he caught his foot on it. I'm not sure what else he has to say that can allow this case to go to the jury, for the jury to say that this was a negligent condition and that it caused him to trip and fall. Because the door was open, he fell down the steps. The superintendent testified that the door was always kept closed. Had it been closed, he wouldn't have gone anywhere because the door, when it's closed, is right up against this condition and nothing would have happened. I think my adversary is going to refer to the hospital history, so in anticipation of that, I'd like to just respond that no one knew French, that there was an interpreter used. Every witness testified that there was an interpreter used. No one understood French. His preferred language, as shown on the triage and the intake forms, was French preferred. The interpreter was used, apparently, I'm not sure what it entails, but it's called Cyricom, and apparently the defendants had plenty of time to arrange for whoever that person was with a number to come and testify as to the accuracy, the competency of his or her interpretation and objectivity of the interpreter, and that wasn't done.
Counsel, can you address your trial counsel's summation?
Your Honor, the summation was certainly not at all egregious. Objections were many from the defendant's attorney. They were all addressed, sustained or not sustained. The court advised the jury to disregard comments from the plaintiff's attorney, where she said that he was veering into the court's lane in terms of charging or telling the jury about the law. There's nothing at all about this summation that is anything that unduly affected the jury. The verdict would have been the same with or without the comments. And I think that if a new trial is granted on this summation, then there'll be hardly a case that's tried that doesn't go for a new trial on untoward comments. Again,
They went pretty far, counsel.
Excuse me?
Those comments went pretty far.
Oh, I don't really see it that way, Your Honor. I think the court made sure to instruct the jury not to be influenced by counsel's comments. They had a chance to be dismissed for the day and came back the next day for the charge. And at best, you might conclude that certain comments shouldn't have been made. But in totality, this case went on for a couple of weeks, a lot of testimony, and the jury had time to reflect and consider. I don't think there's anything that can be said that was so untoward that the jury was unduly influenced in arriving on its verdict, that but for the comments, there would have been a decision for the defendants. I just don't think it rises to that level. Not every trial is perfect, and attorneys sometimes get carried away. I'm not even sure that this attorney did, but if you conclude that he did, was not so egregious, as I said, that the jury was unduly influenced.
Thank you.
Thank you.
If I may just skip to the admissions in the hospital, I'll skip to the point of law that I think is most important. I think it's black letter law in this department that a statement in a hospital record is admissible as an admission where it is clear that the plaintiff was the source of the statement and the translation was provided by a competent, objective interpreter whose translation was accurate. In this case, the first part of that sentence, the source was established as to Nurse Chinhen's statement. She testified. She did not testify through a translator. The court found that credible. So as to her statement, that should end the question. As to the other two statements, as well as Nurse Chin-Hensva's statement, if there's any question as to whether the court accepted that, she testified through Siricom. I think it's clear that we established that the translation here was accurate. Siricom, as every medical professional testified, was relied on as part of the hospital procedure. Even Nurse Castillo explained how the procedure worked. There's the blue phone, and they each take one phone, and it's done simultaneously and at the same time. As one is speaking English, they're French, they're interpreting into English, and it is exactly what any witness would bring in if they brought in the translator, if it's even possible to bring in the translator from Siricom through the number, and that's.
But how do we know it was accurate? There was no testimony from the interpreter to even indicate that it was accurate. So how do we know that?
All we have with Siricom is a number. You don't have a name, and the court actually denied our request for a subpoena to Siricom, but as our later research showed, and which we put in our motion, that it would not have meant anything. They don't preserve their records, but keep in mind that a translator is not a witness to the transaction. So any translator who came in could only testify as to the procedure that they used, just as the medical professionals who relied on this for treatment testified as to the procedure for how Siricom works. And it's used for treatment in the very same paragraphs, statements that they took as to how the accident happened in another place other than the door saddle. But putting that aside, they also took medical treatment. They relied on this, and they rely on this. Hospitals, as you know, hospitals throughout the country rely on this for treatment.
Counsel, I find it unusual for you to argue that these hospital records, that these statements, alleged statements in the hospital records were germane to treatment or diagnosis. You really want to reach the issue of causation. All you need to know is that the person slipped and fell, not where or how or anything else.
Your Honor, we're not arguing they're germane to treatment. We're arguing that under the case law, it doesn't have to be germane to treatment for a hospital admission to be admitted if it's connected to the patient.
The language of the statements is generalized language. It's not, there's no quotations here, counsel.
There's no need for quotations. I mean,
But it's not in the first person. So
that
then one has to consider when it's not in the first person.
Except that there's many cases where it's not in the first person, here she said he complained of, which is really no different than he reported. And as to the other statement, and later in the paragraph she said he reported. So she's clearly speaking to him. She's right there, she's speaking to him. This is clearly a statement. And many of the cases, they don't have.
It's clearly, it may be clearly a statement, but it's another question is whether it's admissible, right?
I think it's admissible under the case law we cited that most of these cases, including Martinez, they don't have I from the patient. I fell. It's not necessary. If it's a statement, and the witnesses all testified, it was his statement. It was his words. Each of them, I mean, you almost never have this. They each testified that it was his words, and they would only have taken down his words, and that's a statement, and that's an admission. That's what this is, and it's an admission, and under the case law, if it's connected to the patient, which it clearly was here, it should be admitted, and here the translation, unlike in Nava Juarez, unlike in Sanchez, here the translation was identified and reliable. We knew the exact procedure that was used, the same procedure that's relied upon for treatment. And if I just may skip to the summation, which was...
Counsel, I think we understand the issue, and I've given you quite a lot of extra time. So thank you.
Thank you.
Thank you both. Caraballo versus Mount Sinai.
May it please the court, I'm Annette Hassapidis, appearing for the plaintiff in this case. The issue here is really how long of a toll did the plaintiff need here for the complaint to be sustained and the motion denied? Less than 3 months. The last visit that the plaintiff made was on July 28th, 2015, I'm sorry. And
then the plaintiff was supposed to return.
Correct.
Had an appointment with the doctor for September 1st, and the plaintiff did not show up, just didn't show up. Instead, the plaintiff went to a different hospital, Mount Sinai, I believe, and told the doctor something to the effect of, I'm coming here because I really didn't like it over there at New York Presbyterian. So he actually tells the doctor,
yes,
I'm coming to you for what I was over there for. I want you now.
Your Honor, I will embrace those facts as you've laid them out. And I would submit to you that the continuous treatment doctrine told the claim long enough for our complaint to be timely. The last personal visit was on July 28th, 2015. We would have had to have filed the complaint by January 28th, 2018. Instead, we filed it less than 3 months later on April 17th, 2018. If you conclude that the physician-patient relationship terminated when my client went to Mount Sinai, Queens on October 21st, 2015, the doctrine, the statute of limitations, would have been told until April 21st, 2018. We filed the complaint 4 days before that.
Why wasn't it told when he decided not to show up anymore at his doctor on September 1st?
Because he made a call to the hospital on September 9th with a question about his prescription and asking that the pharmacy be called. And while defense counsel has insisted that my client did not call, I've actually reproduced the note in the reply brief that literally says, it has an emoji essentially of a telephone, and it says, Jeremy Caraballo called, spoke with another woman there. It's at page 573 of the record.
You're talking about the September 9th call.
That's correct.
That wasn't a call from an automated call from a
It was
pharmacy
not.
about his
No.
prescription?
No, it was not. The defendant's own records, again, page 573, I actually reproduced it in the reply brief at page, excuse me, I mislaid my reading glasses, so if I'm a little off. I apologize. Reply brief at page 8. It says, Jeremy Caraballo contacted Fanita Amos, September 9th, 2015, 9:37 a.m. It's denominated conversation, medication problem. Fatima Amos routed this conversation to Marcus de Silva Gonçalves, ND. So my client did make a call. This wasn't, now Dr. Gonçalves in his affirmation on the reply said that it was a routine fax from CVS. The pharmacy records are from Christides in any event, but the defendant's own records raise the question of fact. My client was making a call about a prescription on September 9th. He was still using the medication. Again, Your Honor, if we use the date of October 21st, when my client went to Mount Sinai, Queens, there's no question and there's no evidence that he stopped using his insulin and other prescription medications in accordance with the course of treatment established by the defendants between July 28th and October 21st, 2015. And the complaint would be deemed timely filed by 4 days if you use the October 21st, 2015 date. The defendants did not dispute that the symptoms that were treated were for the underlying condition. They did dispute that the plaintiff made those complaints. Now, I'd address that in several points here. First of all, on the underlying motion at page 26 and 27, they conceded for the purposes of the motion that the records of all of the clinics would be imputed to New York Presbyterian. They're bound by that on this appeal. The records from the clinic show that my client made the complaints that were related to his condition. May I finish my point?
Sure.
Thank you.
And I want to ask one question, counsel. Did
Your
your
Honor.
client put in an affidavit saying that he called on September 9th, 2015?
No, the affidavit was not intended to reiterate prior
I'm
to...
asking you, you said he says he called
Hold
on September 9th, 2015. Did he put that in?
He testified, well, he also
Did
offered
he
his debt.
testify or put in anything that said, I actually, on September 9th, I made a phone call to this doctor?
Your Honor, I'm checking to see whether it was deposition testimony or his affidavit, because it was either one or the other. I believe it was his deposition testimony.
What page do you say he called? He said he called.
Okay,
Because I didn't see anything that he said he called.
it was not in his affidavit, Your Honor.
It wasn't.
Well,
And now you're saying it was in his deposition. Where? Because I didn't see it.
Well, Your Honor, first of all, that presumes that he was asked the question. Secondly, it's the defendant's motion. The defendants proffered the records. It's their own records.
The defendant said, this is a fax from a pharmacy, and that's what we have. And now you are saying, no, it's not. My client called, and I'm asking you, where did you put that in controversy?
We put that in controversy by citing to the defendant's own records at page 523 of the record.
And then the defendant explained the record and said, this is what this is. Now, that's unrefuted. I'm going to just ask you one more time. Did your client testify or put in an affidavit that said he called? And then I'm letting it go. I promise.
Give me a moment, Your Honor. Your Honor, I don't see that that is the case. However, I cannot say that my client was asked the question at his deposition, whether or not he called thereafter.
In response to a summary judgment motion that says, the only thing that somebody puts in an affidavit that says, no, this is a fax from the pharmacy. Did you put in either deposition testimony or an affidavit that would dispute it?
Your Honor, this was not summary judgment. It was a 3211A5 motion first.
Oh, I'm sorry.
It's quite all right, Your Honor, but my burden is a bit different. And frankly, Your Honor, relying on the defendant's own records that are unambiguous is more than appropriate and frankly far more credible than what the defendants would call a self-serving affidavit. Thank you for letting me conclude my point.
Where you have rebuttal.
Good afternoon. May it please the court. Patrick J. Engel, Keller, O'Reilly, and Watson, representing New York Presbyterian Hospital on this appeal. The bottom line on this here is the last treatment that the plaintiff received at New York Presbyterian Hospital was on the 28th of July of 2015. There is no record of any other additional treatment or actions by New York Presbyterian with regard to plaintiff's treatment for diabetes. He was going, what the situs of this whole argument is over, he was going to it.
Excuse me, counsel, how do you respond to plaintiff's counsel's argument that the plaintiff was the one that called on September 9th?
You say that again, Your Honor? I didn't hear you.
What's your response to the argument that you just heard counsel make that it was the plaintiff that called on September 9th instead of a pharmacy?
The plaintiff, there is no record, in the record, there's nothing that shows that plaintiff called. We put it, the New York Presbyterian put in an affidavit from the doctor who says that, who plaintiff's counsel says that was talked to and said, I never got a call from the plaintiff.
Counsel, may I interrupt?
Sure.
So I have the benefit of working from chambers today, and I'm looking at page 573 of the record. I don't know if you have access to it the way I do, but it's entitled Wild Cornell Endocrinology, Reason for Call, Facts from the Pharmacy Regarding an RX, AKA prescription. And then it says Conversation Medication Problem. Jeremy Caraballo contacted Fanita Amos. Fanita Amos routed this conversation to Marcus da Silva Goncalves. And then there's a notation here, Marcus da Silva Goncalves, MD, note these, and I'm not saying the name of the pharmacy on purpose, but these pharmacy alerts are not useful. So there's apparently there's a communication that gets to the doctor.
Regarding the pharmacy, from the pharmacy, not from the plaintiff. That's the whole.
But apparently there's a call from the patient to endocrinology, and that conversation is routed to Dr. Goncalves.
Well, as explained in our papers, that was not a call, it was a fax received from a pharmacy, and the matter was brought to the doctor, the endocrinologist, and he said, these are not helpful. He's reacting to fax, not to a telephone call. It's a fax. He says it. He says it relates to the pharmacy. He's not mentioning that it's relating to
I
a
hear you,
patient.
but I'm looking at the line at the entry that specifically says conversation, medication problem, and then underneath that, it says, had a little phone with a little arrow, and it says Jeremy Caraballo contacted Fanita Amos.
Yeah,
So
and like I said, I have an affidavit from the doctor saying that was the ministerial act of New York Presbyterian Hospital. They received a fax and they're reacting to the fax. And the doctor specifically said that's exactly what this was a fax. It wasn't a telephone conversation. And as pointed out, the plaintiff, in opposition, in their reply, put in an affidavit from the plaintiff, makes no mention of this September 9th, 2015 conversation.
Counsel,
As a matter of fact, it's nowhere in the record, as correctly pointed out by Your Honors.
and would you characterize this as ongoing treatment?
Not ongoing treatment. The case law is pretty clear. What happens is there was a prescription issued in July of 2015 that allowed for refills, and this is just a ministerial call or fax relating to the prescription, not from a pharmacy that's unclear of the exact dosage or of how it was to be prescribed. Doesn't go to treatment or additional treatment. It's just relating to an ongoing prescription.
Counsel, I don't have the benefit of having the record before me, and my memory is failing me. Is that fax part of the record?
Well, it's actually reproduced in the record. I believe it is, Your Honor. I could probably dig it out if you want. I have the whole record with me. But
you can proceed. I'll dig it out.
But the whole point of this being that when you look at continued treatment, you don't look at the date the plaintiff expresses some dissatisfaction. It's when they went for the last treatment, and the plaintiff's last treatment was in July of 2015.
Thank you.
Thank you, Your Honor.
Thank you. I've reviewed the plaintiff's deposition testimony as quickly as I possibly could. He was not asked any questions with respect to the month of September. If you look at the index from his deposition, September appears only at page 10 of his deposition. It has nothing to do with treatment. So he was not asked about making a call in September based on my quick review. I'd like to point out that if a defendant could resolve away or write off what they claim is an error through the affirmation of their own witness by a reply, the defendants would prevail in every summary judgment motion. Frankly, I know the court was concerned about why the plaintiff didn't proffer deposition testimony or an affidavit. What better evidence do you need that the plaintiff made the call to the hospital with respect to treatment on September 9th than the defendant's own records? If that isn't enough, and if the defendants can file a reply affirmation from a physician who, frankly, in his affirmation does not make statements based on his personal knowledge, review of the records, or anything, but simply at page 1879 says, Kelly O'Reilly and Watson, PC, attorneys for New York Presbyterian, have requested that I provide this affirmation in response to statements in plaintiff's attorney's affirmation in opposition and plaintiff's affidavit. Not personal knowledge, not based on a review. So apparently this—
Counsel, if I may.
Yes.
Counsel, if I may. So again, I'm going to this document where it says Jeremy Caraballo contacted Fanita Amos. Does the record anywhere identify who Fanita Amos was?
Apart from
whether she worked for the hospital or whether she worked for the pharmacy.
This is a record of the endocrinology clinic. I think a fair reading of this
No.
is,
I'm not asking about a fair reading. I'm asking you, do we know the identity of Fanita Amos? Now, it does say that she routed the conversation to the doctor, but is Fanita Amos a worker in the pharmacy of Weill Cornell? Or is she someone who works with Dr. Goncalves? Do we ever have that clarification?
no, we do not. And I'd submit to you with respect to all the issues surrounding this page of the record, the fair reading of it, or at least my reading of it, was that they received both a fax from CVS and they received a call from the plaintiff on that date. That this is not a situation where just the plaintiff called, because there is a reference to a fax. But it specifically says, and there's the telephone emoji there, Jeremy Caraballo contacted Fanita Amos. Fanita Amos is simply somebody who routed the call to Dr. Goncalves. I would submit that her status is not necessary because she routed the call to Dr. Goncalves. So
and
she
then
was a
we
conduit.
counsel, we get an affidavit from the doctor who said he never spoke to your client, and then you put in a reply, right? And you don't, and your client doesn't ever say, no, yes, I did.
I'm sorry, Your Honor.
Correct? Am I
Could you repeat that? Could you repeat
Essentially,
that?
your client never came back with an affidavit in response to the doctor's affidavit, even when it had the opportunity to do so on reply.
My client had no opportunity. Dr. Goncalves' affirmation was filed on reply. I couldn't file a sub-reply. I was precluded from doing so. So I really was in no position, my client was in no position to respond to that. He had the best evidence. He had the defendant's record saying that he called concerning a medication problem on September 9th.
And this issue didn't come up before.
I'm sorry, let me just say, the defendant made a motion to dismiss, correct?
Yes, 3211A5 motion.
Right, and then in
opposition.
Got it, okay.
Right, plaintiff proffered an affidavit. Dr. Goncalves' affirmation came in reply. We had no opportunity. Thank you, Your Honor. Thank you for the additional time.
Do you have a question? Just a second.
No.
Do you have a question? Okay, thank you very much. Thank you both. People versus Sisman, Jodorowsky.
Good afternoon, Your Honors. I am Mark Baker on behalf of Simon Chodakowski. May it please the court. I submit that the result that I seek this afternoon, which is a new trial, is dictated by the Court of Appeals, almost 80-year-old case in People versus Liotti. They are similar to what happened here. Prior to the verdict during voir dire, the particular juror in dispute had professed impartiality and a lack of prejudice towards the defendant. Yet he stated after the trial that the testifying Sicilian defendant was probably guilty because he wouldn't believe a Sicilian under oath. The Court of Appeals had a situation where the trial judge declined to hold a hearing, and according to the Court of Appeals, because the affidavits were not denied, they were said to stand as conclusive proof of disqualification.
Is that the same as the case here, where in that case, the juror says, I wouldn't believe, clearly expresses
Yes.
clearly expresses his opinion and said, I wouldn't believe a Sicilian, or whatever you said. I wouldn't
the
believe
defendant
it.
must be guilty because he's a Sicilian.
And I think you said, and I wouldn't believe a
Yes.
Sicilian, right? So he clearly articulates his thought process and everything else. Is that the same?
That's correct.
As here, where I think the woman says, let me find it. She says, oh, she's a good...
nice Jewish girl, a good Mensa, while the defendant was a big dumb Polak.
Right.
And the trial judge determined
I'm saying, is that the same as her expressing, you know, I would never believe him because he's, you know, of whatever persuasion he's of?
I think it's a distinction without a difference, Judge Roscoe. The fact of the matter is that it didn't just say he's a big dumb Polak. He compared it to the complainant, who was a nice Jewish girl of good mensa. Now that is saying the same thing as what was said in effect in the Liati case, where he's not believing somebody because he's a Sicilian. Here he's saying he's not believable because he's a big dumb Polak. And that was undisputed. The trial judge accepted that as true for purposes of the holding in the case. But let's go back to Liati for a minute. The Court of Appeals there said, as the affidavits stand undenied, they constitute convincing proof that this salesman never was eligible to become a member of the jury, that from the beginning he was disqualified on the ground of prejudice, and his vote for conviction is a nullity. The court, in this two-page decision, pointed out that this is not an impeachment of a juror case. This is a case where, based upon what this juror later said, he was not eligible from the get-go. That's the same thing here. Because this juror's statement have been accepted as true by the motion court, it is now established that he said that this defendant could not be believable because he's a big dumb Polak. This court did the same thing in People versus Rakaj, the third department.
So, counsel, is it your contention that even though there's no indication that this language affected the jury's deliberation or the jury's verdict, that the issue really is simpler than that?
Yes.
It has to do with the empanelment of this particular jury and the selection of this particular juror?
Yes. People versus Liati, the Court of Appeals did not even get into a discussion or the issue of whether or not other jurors were tainted. It said this juror was disqualified from the beginning, so therefore his vote is a nullity, and therefore you don't have a full jury. I would submit to the court, however, alternatively, we certainly should have had a hearing on the question of juror impeachment because of racial or bias. The fact of the matter is that the magistrate, as I said before, not the magistrate in federal court had said that this judge, most probably, when hearing the case in a state motion court, would find that this was an actionable statement.
But counsel, there were no jury notes here. This was a unanimous verdict after only 4 hours.
That's correct.
And the foreperson apparently has some regret 10 days after the trial.
Correct.
How does that weigh into your analysis?
I submit, well, first of all, we don't have a record as to what happened because the court declined to hold a hearing. And this court, on motion of trial counsel, I believe, Justice Renwick, you were on even that panel, denied the motion to find out juror information so a hearing could be had and a motion could be prepared. But in this case, the fact that it was 10 days, I can only surmise you have a jury foreperson who has got to consider getting involved in this process, putting himself in jeopardy, perhaps, in his own mind, until finally his conscience told him this is what he had to do. But I refer you to the case I cited in the brief, United States versus Smith, 2018 Westlaw 192-4454, where on this ground, under Pena-Rodriguez, a new trial was ordered, and that was 5 years. The trial was December 2012. The finding of the juror's statement was 2017. I don't think, Justice Renwick, that the issue comes down to when or how long it took. The fact of the matter is, I see my time is up. Let me just finish my point. The fact of the matter is that this juror was uncontradicted. The motion court accepted as true this statement. Once that is accepted as true, People versus Leonti orders a new trial. In the alternative, if there is to be a hearing, which my adversary consents to, that would be more for the purpose of Pena-Rodriguez versus Colorado, the question of impeachment by racial bias. If that is the case, I ask,
Counsel, I'm going to ask the indulgence of our Justice presiding to ask you one more question. Justice Renwick, may I?
Yes, just ask the question.
People v. Peña Rodriguez held that not every offhand comment indicating racial bias or hostility will justify setting aside the no impeachment bar to allow further judicial inquiry. What say you here?
I say that this is more than an offhand comment. This is a comment where the juror, had now accepted as true, made a statement comparing the veracity of the defendant to that of the complainant. And if that is how the juror was thinking, then the juror was biased because of the defendant's ethnicity. And I don't think there's any way that that can be disputed for purposes of impeachment by bias without a hearing. On the other hand, the fact that the matter was stated under Liotti by the Court of Appeals is enough to say that he was nullified from acting as a juror in the first instance, and therefore there was a reversal. And by the way, the Court of Appeals was acting as the factual review court in Liotti, and they reversed in the interest of justice.
Counsel, Justice Renwick has given me permission to pose a question, and this is the question. So you don't move to set aside the verdict, rather you ask for an adjournment to conduct the full investigation. So you did that, you interview the juror, and then 3 years later, you move, the 44010 using the same affidavit.
Yes, because this court, in a motion by trial counsel, denied the opportunity for information about the jurors where an investigation could be had and inquiries could be made. For purposes of this motion, quite frankly, I had a federal magistrate who said that that motion, in agreeing with us, that juror's statement was enough to warrant a hearing, and she had every expectation at the motion court and state court would order a hearing based upon that statement. Obviously, Justice Mandelbaum didn't do that. He didn't even reference the magistrate's sentiments in that regard. But the fact of the matter is, we had the juror's statement that trial counsel procured on an affidavit. We didn't have the access to the rest of the jury, so we were left with what we had.
Thank you.
Thank you very much.
May it please the court, Beth Fish Cohen for the people. We submit that this case is nothing like Leonti. There's absolutely no indication that this juror was from the start unable to treat people fairly. I remind you that the affidavit from the foreperson was a laundry list of complaints. This was one of many things buried within it. And in terms of the standards set forth by Peña Rodriguez, the motion court correctly ruled that there was not enough to show that this statement affected deliberations or a verdict. We recognize and we consented before the motion court, and we did as well before this court, that there could be additional facts supplemented by calling that foreperson, and so we took the step of consenting to that. We do not think there's anything in this decision that suggests it cannot go back to the same court. The court did not express animosity. The court did not show any predisposition to the facts. The court made very valid points about procedural failures that have been raised by this court and the federal court. The way it was handled at the 330-30 level, the way it was handled at the 440 level, there was absolutely nothing preventing them from going back to the same foreperson and supplementing the affidavit. So I don't think the decision not to hold a hearing in any way suggests that that motion court, that trial court that had observed the jurors, that saw them being polled, that knows the whole history of the case, could not abide by an order from this court. If this court decides to send it back for a hearing, we have every reason to believe that is the appropriate judge to handle this. And of course, we do have a preference for the case to remain in state court and if there's going to be a hearing.
And you consent to the hearing? You have no objection to the hearing?
We have consented to the hearing, yes, Your Honor.
Okay.
If there's no other questions, I'll.
Sorry.
Counsel, that would sort of clear up the whole issue, wouldn't it? Having a hearing. Have that juror testify, and that would clear up, or at least have a more robust record to see whether or not saying she was this and he was that was, because I don't think there was specific language by that juror, and therefore I don't believe. Correct?
That is correct, Your Honor. Yes, we
So a
believe.
hearing would really just clear that up.
Yes, Your Honor. That is the reason that we are consenting to a hearing in this case. If there's no.
Thank you.
Okay, thank you.
I just want to add that if you do consent
Counsel,
to...
excuse me, I don't understand. So the people have consented to a hearing.
Yes,
So why didn't you say that at the outset?
I did. I said that.
Did you? Did I miss it?
Yeah, I said the people consent. I said because they are being
It's in the
pragmatic.
papers, isn't it? It's in the
Being
papers.
pragmatic because the federal magistrate suggested that there would be a hearing in motion
Forgive
court.
me.
That's okay.
Forgive me.
I call to your attention People versus Thomas, upon which Justice Kennedy sat, 190 83rd 652, where the consent of the people was basically all the court needed to hold that hearing. But I ask this, if there is to be a hearing and not an outright reversal under Liati, I ask the court to revisit its decision on the motion the trial counsel made for juror information under the judiciary law upon which you sat, Judge Renwick. We would need that information to be able to have a proper investigation and to air this completely before the motion court. Thank you for your attention.
Thank you both. Kariorgu versus Trustees of Columbia.
Good afternoon, Your Honors. May it please the court. Andrew Schilling from Buckley LLP on behalf of Defendant Appellant, Columbia University. The court below should have granted Columbia's motion for summary judgment. There were two issues before the court on that motion. Number one, did Columbia offer evidence in admissible form of a legitimate, non-discriminatory reason for its decision? And number two, did plaintiff come forward with evidence that showed pretext or showed bias on the basis of either gender or marital status? The court clearly erred in this case because the court said in its decision that there was no evidence in the record to support Columbia's legitimate non-discriminatory reason. That's clearly wrong. We have the affidavit from the decision maker, Dr. Zucker. Dr. Zucker put in a sworn statement and said the reason we withdrew the invitation to Dr. Kariorgu is because the invitation had been extended in the first place because of her collaboration with Dr. Gogos. And when we learned subsequently that they were no longer collaborating, we withdrew the invitation.
This is a question because she began her research long before she even started working with Gogos. So if they're really collaborating, I mean, how can that be? She's conducting her research way before. And also, the invitation was extended to him, I believe, in 2009. So if they're really collaborating, why didn't she get the invitation at the same time? That's two questions. I put it all together in one.
I have two answers, Your Honor. Number one, it's undisputed that Dr. Gogos and Dr. Kariorgu were collaborating for years prior to this. It's also undisputed that Dr. Gogos was part of the initial group that seeded the institute. The institute is a neuroscience institute, and he's a member of the neuroscience department. Most of the members of the neuroscience department joined the institute in 2009, but the building that was going to house the institute, the green building, hadn't been built yet. And
Okay, but
so-
look, the question is, really, the underlying question here is, why aren't there questions of fact? So he was asked first, right, because he's part of the neuroscience department, and that's what the institute was for. But there were other people who were asked independently. And you say that she was asked because her work was conditioned on her ex-husband's, Dr. Gogos. And she says, not true. She says it wasn't conditioned on my working with him. I was independent. We worked together, but I had my own work. So that's number one. Number two, hasn't she raised issues with regard to her claims for both marital status and gender discrimination? And isn't there at very least a mixed question here, mixed motive? I don't understand why there's no question of fact here.
Well,
That's
Your Honor,
why you started off saying you don't know why that your summary judgment motion was denied. Well, usually denied when there's some question of fact. Why isn't there one here on these facts?
well, because aside from arguments of counsel and just uncorroborated statements by Dr. Carriorgo, there was no evidence that she was invited independent of Dr. Gogos. All of the
Well, what about the text, I think, that came from, I'm not looking at the record right now, but that came from her friend who she stopped and asked, and he said, well, they just weren't together anymore or something like that, so we really couldn't have them together there. I mean,
Right,
what about that?
That evidence actually corroborates the legitimate non-discriminatory reason, because what Dr. Giselle said in that email was that they were going to integrate Dr. Carriorgo's lab into the existing member, Dr. Gogos's lab.
Well,
And
counsel,
because they found out
isn't
that...
there an issue, counsel? So Dr. Giselle sends an email to Dr. Candell in 2016 saying, well, we thought we had a primary allegiance to Joseph, especially since Maria's space was integrated into Joseph's. So when the acrimonious separation happened, there was little choice but to back Joseph. And yet, from what I was reading in the record, there's an allegation that Dr. Jessel previously introduced the plaintiff at a fundraiser for the MBBI Institute as the goddess of genetics. He, who was it? Dr. Candell called her the most important and distinctive investigator working on the genetics of schizophrenia. Dr. Lieberman, the chair of psychiatry at Columbia, said that she was a national eminence as one of the limited number of psychiatric geneticists in the world. So the way that the ex-husband and frames the issues, he was the big guy and she was the little fish that followed him. But it seems like this is something that has to go to a jury, don't you think?
My light is on. May I answer Your Honor's question? I think this is exactly the error that the court below made. The focus of Dr. Carriorgo's opposition to the motion was to talk about her accomplishments and her scientific discoveries, and there's never been a dispute that Dr. Carriorgo is an impressive scientist with an impressive record. But the facts are that not everyone with an impressive record is invited to the Institute, and that the facts are that the reason she was invited to the Institute was to continue a collaboration, not in a subservient way, but a continued collaboration with the doctor that she had been collaborating with for years before that. And if she was going to be invited...
This is Judge Scarpula. Is there a written document? Is there a written job offer to her that says your offer is conditioned on your working with Dr. Gogos?
No, and that's exactly the point, Your Honor, is because...
So she says, no, that wasn't true. And your witnesses, yes, it was. And we don't have a writing either way, correct?
I disagree, Your Honor, because the point...
What writing do we have? Did you make her a formal offer of employment? Does her offer say that it was conditioned on her working with him?
No, and that's precisely the point, because the undisputed evidence was that if you're going to be invited to the Institute as a member...
It's not undisputed. She disputes it. She says that is not true.
But
she disputes it.
But she disputes it by saying they invited me as a full member, but the undisputed evidence was that if you're invited as a full member, there is a record. There's a letter, there's an offer letter, there's a memorandum of understanding with your home department. There are none of
And
those
otherwise,
documents exist.
you don't get a letter? Even if you're invited as conditioned on somebody, you don't get a letter? That's what you're saying? Columbia only gives letters to some people, not others?
No, it's the difference between being invited as a principal investigator with your own lab, which was not the case here. The evidence was that there was going to be a single lab for the two of them.
Well, there is no evidence because it's not in writing.
Well, there's
You
evidence
say
in the
one
form of
thing, she says
contemporaneous
the other.
emails.
That's what I started off saying. She says it's a pretext.
Right, but she has to
Anyway,
come
your
forward with
time is
evidence
done.
of a pretext.
Okay, you have.
Her own testimony
Wait,
is.
there's another
That's
question.
her own testimony.
Okay. Did you want to answer? Oh, I'm sorry, you had another question. Go ahead.
No, it's fine. It's okay.
Okay, so you have 2 minutes rebuttal.
Okay, thank you, Your Honor.
Yes.
Please the court, my name is Brian Heller of Shorts, Perry and Heller. I just want to touch on one topic. This case is about pretext. This idea that the plaintiff was only invited because of her husband is a pretext. Now, defendant says that that's uncorroborated, but it's her own testimony, and the truth is there's no documents regarding her invitation. They say she would have gotten an invitation. Well, Dr. Gogos, the husband, didn't get his invitation until 2018, years after the events we're talking about. Let's look at the facts before her invitation was rescinded. Her invitation did not come from Gogos. He had nothing to do with it. There's no evidence of him having any input. She met with Zuckerman, who the institute was named after. She spoke to fundraisers and to people who were potential donors. The only reference that anybody made when she was given the offer was, do you want your lab close to him, or are you sick of him by now? She was invited on her own merit. And this argument that her admission was tethered to her husband, it's insulting, and the lower court properly called it sexist.
Counsel, if I could just ask, is it accurate that they had separated before she was invited to join the institute?
Yes, they had separated before. And the key moment when her employment changed was when her husband, her ex-husband, wrote an email to Dr. Jessel and Dr. Zucker saying, she's not coming with me. But take a look at this email. He says, the idea that she can even be at Columbia, as well as the idea that she may be collaborating with colleagues at MBBI, is appalling to me. He says, the way I feel right now, our existence in the university is mutually exclusive. If she was really coming with him, he would have been able to rescind the offer himself. He wouldn't have had to go through them. He even disparages her and refers to her lab. He acknowledges that she's different, and he tells them, I don't want her to come, and they kowtow. And they say to Dr. Carriorgo, we got an email from Gogos, you guys got divorced, and he said he would be uncomfortable. I'm sorry, but we're taking back the offer. And she protests, and they say, it is terrible, but we just don't want to start the institute with controversy. She sends an email 2 days later complaining. She says, you made me an unconditional offer to join MBBI, and then following my doors, you can no longer have me. And 6 weeks later, she gets an email from someone completely different saying, I understand that you had a discussion last April about the possibility of your having a presence at the Zuckerman Institute. That's the first time anybody ever mentioned the phrase presence. It's completely made up in those 6 weeks. You've got to wonder how many people reviewed the draft of that email. If you look at her email accepting it, she refers to it as being an honor. It's not an honor to have a presence because of your husband. There were questions of fact here. The lower court was correct to deny summary judgment. This court has a long history of denying summary judgment where there's questions of pretext.
Now,
Defendant-
counsel, there was also, I believe it was in April 25th, 2014, email from the plaintiff to Jessel and Zecker, I hope I have the names correct.
Yes.
Saying that she accepted the invitation to play a role, but there was no mention of Gogos. Am I correct about that?
That is correct, Your Honor, and that it was an honor. When she said she wanted to play a role, she was trying to be humble. Columbia has tried to say that that's her acknowledgement that she wasn't a full member, but that's a pure question of fact. She vehemently disputes what the reason was for her invitation. The only evidence that they have comes after the offer was rescinded. It is an affidavit that was signed after her complaint. There was statements made when she complained about discrimination. There's nothing in the record. The lower court was right. And one other point, they had said to her when they rescinded the offer, maybe there's an affiliate membership that we can provide. And she was interested in that, and she kept pressing for that, and it never came true Because what happened was Gogo said, I don't want her in the university, and that's exactly what the university did.
Thank you.
Thank you.
Your Honors, in one respect, I do agree that one of the most important documents in the record is on A129, which is the email that Dr. Jessel was referring to. I don't believe a reasonable juror could read that email and conclude that the reason that the disinvitation occurred was because of the divorce, as opposed to the undisputed acrimony between these parties. They had orders of protection against each other. They were sending caustic emails to each other. She admits in her emails in February, we do not collaborate anymore, to her husband. And I want to make the point again that there's two issues.
Counsel, if I may, under those circumstances, the university has many options available, including calling in human resources, seeing if there can be mediation, putting people in separate labs. Orders of protection, unfortunately, are not unique to any large institution. I'm sure Columbia has dealt with this situation before. But to terminate someone summarily is a question that whether she was arbitrarily terminated, wrongfully terminated, would seem to be a question for the jury.
Your Honor, she wasn't terminated at all. This was a situation where she's being invited as a member of the Department of Psychiatry to join an institute for neuroscientists.
Disinvited was the word my colleague meant, not terminated, obviously. Disinvited from that place.
Right. The other point I would make, Your Honor, is that there's a difference between being offered a presence and being offered membership. There's documentation around membership. It's informal around presence, which is why there is no correspondence. The fact that
there was already a point made by one of my colleagues that the letter didn't come in until so much later.
I don't think the record actually supports that Dr. Gogos' letter came in later. If you look at the record site that the plaintiffs cite for that, it doesn't support that proposition. The last point I just want to make is that, as Dr. Zucker explained, there are other people who were offered a presence at the Zuckerman Institute who were men. And so it cannot be an issue of gender discrimination that a prominent scientist is invited to collaborate with another prominent scientist, because that's what an offer of a presence is. It's an invitation to another scientist to collaborate. And so there's nothing demeaning about it. There's nothing insulting about it. And so there's zero evidence of gender discrimination with respect to this. Her only evidence of gender discrimination.
Counsel, I just want to clear something that you said before with regards to the orders of protection. It appears from my notes, and correct me if I'm wrong, that the email that was sent by Gogos was on March 1st, 2015, and then her offer was rescinded on, or whatever you want to call it, on March 12th, 2015. But the orders of protection weren't issued until a month later, on April 24th, 2015, and then the other order was issued on May 15th. So at the time that it was rescinded, the orders of protection were not in effect. Is that right?
That's absolutely correct, Your Honor. But it's also fully consistent with the testimony of both Dr. Kariorgu and Dr. Gogos that as of February, they were not speaking to each other anymore. As of February. And then the email comes in March saying that I cannot work with Dr. Kariorgu at the Institute. She's not going to come with me, which is evidence, contemporaneous evidence of the expectation of everyone that she was coming with him. And
well, he went further, Counsel, he went further, right? He didn't want her in the university.
I'm sorry, Your Honor?
Dr. Gogos went further. He didn't want her in the university. It wasn't simply he didn't want to work with her. He didn't want her at Columbia.
Absolutely, Your Honor. He was obviously very upset about this, and it only goes to show the depth of the animosity between them. That it was completely untenable for the directors of the Institute to say, we expected you to collaborate with this person, which is why we offered you a presence. And now it's clear, based on this level of animosity, that you're not going to be collaborating with this person. Therefore, the reason we extended the invitation in the first place is no longer valid. It's a completely legitimate decision to have made.
Any questions?
Except her testimony is that it wasn't conditioned. And I know you want to say that that's nothing, but that raises an issue of fact. If she says that my invitation was not conditioned on that, and you say it was, I don't know how you can ignore her testimony.
Because for her testimony to be accepted, there would have to be evidence. The lack of a letter, again, the lack of a memorandum of understanding with her home department, it's
But
evidence
there's not,
she
that
was
goes
not.
both ways. That cuts both ways. So her affirmation is as good as what Columbia is saying, isn't it?
I don't think so, Your Honor. It was her burden at that point to come forward with admissible evidence. Her own affidavit saying, I just disagree. It's not sufficient. It's not evidence.
Okay, thank you
All
very
of the
much.
evidence pointed in one direction here.
Thank
Your
you.
Honor. Thank you, Your Honor.
Thank you both. Gamble versus Honorable Dennis Boyle.
Thank you, Your Honors. Good afternoon, and may it please the court. My name is Terry Rosenblatt, and I'm here for petitioner Dejan Gamble. Your Honors, the legislature created a state DNA identification index for the purpose of comparing DNA from individual people to DNA from all...
I'm just going to jump to the point. What are you asking us to do?
I am asking Your Honor to vacate the decision of respondent and order that Mr. Gamble's DNA not be included in the OCME's municipal DNA identification index.
Forever?
That's correct, Your Honor, and I'll explain why. The reason is that...
Okay, so we already have from this court in the matter of Sammy F. versus Fabricio. And so that decision says that the data back, is the statute, I'm sorry, the executive law, 995, section C, says that the data bank is part of the state system and it is appropriate. So you're not asking us to do anything there, but if you're asking, that section says that designated offenders are required to provide post-conviction DNA samples. Now, if you were saying, well, he's not convicted, which I know is one of your arguments, he's not convicted yet, not convicted. The statute only speaks to post-conviction, and it's limited now because he's not convicted. Well, that's one thing. But when you're saying forever, well, what if he's convicted at the end of this proceeding?
Thank you for asking that question, Your Honor, because that makes the point that we're dealing with here, which is that if Mr. Gamble were convicted, absolutely, he has to provide his DNA to the state DNA data bank. So he will have, and there is a procedure for that that's set forth in Executive Law 995C, which is that post-conviction, a member of the, usually it's a member of the court staff, will take his DNA and they'll send it to the state. So I'm not saying that he never would be subject to DNA indexing in the state index. If he is convicted, absolutely he will be. The difference here, Your Honor, is that pre-conviction, the city of New York has established an ultra-virus sort of shadow DNA index, which stores only pre-conviction samples. And it's the inclusion in the pre-conviction index that we're asking for Mr. Gamble to be removed from.
Is the remedy that you're asking for appropriate in an Article 78 proceeding?
It is, Your Honor. It's the same procedure that was followed by this court in the Sammy F. case. In that case, the petitioner there did move. In that case, it was expungement and not a protective order because it was post-adjudication. But essentially, the petitioner moved in Supreme Court in the Bronx. Once the decision was rendered adversely to him, he did move here in an original Article 78 proceeding. And what this court found there was essentially that there's no other way to redress that decision. And that's something that the Second Department has said as well in People v. Pearson, where they found the denial of a protective order is not justiciable on direct appeal. And since there is no other remedy at law, among the other reasons that are cited in our brief, it is appropriate to bring this action here. Your Honor, just to go back to the distinction that we're drawing here between what the city does and what the state authorizes. Article 49B is a comprehensive statutory scheme, which, as Your Honor pointed out, was appreciated in Sammy F. to control the local lab. What Article 49B says in relevant part here is that a local lab is entitled and empowered to do certain things in testing DNA evidence. It is allowed to test DNA from crime scene evidence. If a profile is developed from that crime scene evidence, it is allowed to upload that profile to the state DNA identification index, where, as I said at the outset, it will be compared to all of the people whose DNA, who have been convicted of crimes in New York.
And to pursuant to what section is that?
That's 995, the definitions section, 6 and 7 set forth the DNA identification index, and 995C sets forth the procedure for the state index, and then 9 and
No. I know that this can be uploaded at the appropriate post-conviction. I'm saying, what is the New York City, what is the local lab, the New York City's lab? What section is authorizing that?
What section is authorizing the city's DNA index? It's an executive agency policy, Your Honor. It's enshrined in the technical manuals of the Office of the Chief Medical Examiner, and under oath at City Council, the medical examiner has also testified in detail to their procedure of having the ultravirus DNA index. Your Honors, and so the third thing that OCME is able to do is, I'm sorry, I see that my time is up, but just to conclude this point, I just want to make clear, the state legislature's clear intent was that only convicted people should be subject to comparison to DNA from cases for which they are neither charged nor a suspect. Under respondent's decision here, Mr. Gamble is in a municipal DNA identification index where he is being perpetually, permanently, and suspicionlessly compared to every crime scene evidence in New York City that has ever happened or that ever will happen, even though he hasn't been convicted of a crime. And for that reason, respondent's decision was an error, and Mr. Gamble's DNA should be removed from that portion of the identification index in the city's.
And I just want to make sure one more time, the municipal DNA index, gathering this gentleman's DNA and including it in their data bank now, is pursuant to what?
It is pursuant to an executive policy that's created by the Office of the Chief Medical Examiner. And in this case, the prosecution also requested that Mr. Gamble's DNA be included in that DNA identification index.
But it's your position that that whole thing is ultra-virus, correct?
Yes, Your Honor.
So you're in essence asking this court to declare it ultra-virus?
I'm asking Your Honor to give Mr. Gamble relief in this case on the grounds that he is not convicted and therefore should not be in a DNA index that compares him to crime scene samples for which he's not charged.
Okay, thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, my name is Melissa Izagari. I'm with the Office of the Attorney General, and I'm here representing the respondent, Justice Boyle. The issue before the court is petitioner's request for Article 78 relief, either a mandamus to compel or prohibition.
Well, why wouldn't this be a prohibition?
Well, Your Honor, the question is whether petitioner had a clear legal right to a protective order. In this case, that there's no clear legal right to a protective order. That's in the jurisdiction of the court. That was in the within the jurisdiction of the court, within the discretion of Judge Boyle. And he exercised his discretion in denying the petitioner's request for a protective order. There's no clear legal right here. I think what petitioner would like to do is here to go beyond what, you know, the clear legal right that does not exist, and have the court declare whether or not the index, the local index, may not be illegal, but or may whether it's illegal or not illegal, or whether it's allowed or not allowed under the statute. But I think here the focus is whether petitioner had a clear legal right to that protective order. The executive law does not give petitioner a clear legal right to that order, to that protective order, and so there's no Article 78 relief in this case. This petition should be denied. And what was before the court, before Justice Boyle at the
Well,
time.
counsel, let me ask you this. How can this be redressed if the city's database is ultra-virus? How do you suggest that that be addressed?
Your Honor, I think the legislature has to act. I think here there's no clear legal right under the present statute, and it would be the place of the legislature to act at this time. At the time that the Justice Boyle made his decision, he did not do
Wait a
anything.
second, you mean the legislature, the New York State legislature should act and say to the city, you may not keep this information?
The legislature has to, yes, Your Honor, the legislature would have to make it clear in this case. There's no clear legal right here under the current statute.
Even though we already have the executive law that clearly indicates that DNA is to be provided post-conviction, the DNA samples.
Well, I think there are parts of the executive law that allow for the local index as well as the state index. For example, in the Sammy F case, there was a pre-conviction sample where the petitioner in that case was moving for expungement of a pre-conviction sample. So there are places contemplated in the executive law where we're talking about the state DNA index with post-conviction DNA samples.
But that, what you just said, presumes that it was appropriate for there to have been a pre-conviction sample in Sammy, and I don't believe that that's the case.
Well, that was a petitioner's request for an expungement, and the court there said that the judge in that case could exercise discretion to either grant or deny that motion for an expungement. As here, Justice Boyle has the discretion to either grant or deny what was before him, which was petitioner's motion for a protective order.
So wait a second, counsel, you're saying that if he's acquitted, he has to go back to court and ask for expungement under the city one?
Well, under the way that the statute's currently written, in this case, he could go back to the Supreme Court and ask for an order for expungement. I think it's not clear.
Even though the statute makes clear that it would never go to the state one?
I'm sorry, even though the statute makes...
Even though the statute makes clear that he would not be included in the state one if he was acquitted, right?
If he was acquitted, he could make a motion for an expungement of what's currently in the local database.
No, but what my colleague is saying, that is true even though under Executive Law 995, Section C, those DNA samples cannot be put in the database until post-conviction. That's what she's saying. What you're saying is true,
Right,
even though
exactly.
that's the question.
So I think in this case here, what was before Justice Boyle at the time was what he had the discretion at the time to either grant or deny this protective order. I think it's not clear under what petitioner's arguing under the statute that he has the absolute right, that petitioner has the absolute right to a protective order. I would submit that that is wrong and that Justice Boyle did not err in his decision because he had discretion either to grant or deny that protective order.
Any other questions? Thank you. Thank you.
May I? The distinction between what happened in Sammy F and here I think is important. Sammy F dealt with storage, right? That's when a sample is taken at a local lab from an individual and it's put in, it's typed and it's put in an evidence locker. It's not compared to the universe of unsolved crimes, it's just stored. That action a local lab is allowed to do. And what the executive law says is that post-adjudication, someone can go back to the court and say, you can no longer store my sample.
Because I was acquitted.
Right. That has nothing to do with what we're talking about here, which is the ultra-virus pre-conviction DNA index that compares Mr. Gamble to all of the unsolved crimes in New York City for now and forever. That's the thing that we're asking him to be removed from. And that has nothing to do with what happened in Samieff, which was post-adjudication dealing with storage. And in fact, this court said we're not dealing with the pre-conviction issue here. We'll deal with that another day, which I suppose is today.
So counsel, may I ask you, when you say there's an executive policy, is it a written policy?
It exists in a couple of places, Your Honor. It exists in the technical manuals and procedures of the Office of the Chief Medical Examiner, which I believe we did cite to and link to in our submissions. There's also been city council testimony where the Chief Medical Examiner and the Chief of Forensics for the NYPD have both explained that policy, and that's also part of the record in this case, Your Honor.
And are you sure that your client's DNA was put into, how do you know that your client's DNA was actually put into the city index?
Your Honor, in a couple of different ways. One is that under respondent's decision, he was put there because respondent's ruling was he can be put there. The second reason is that the Office of the Chief Medical Examiner reports state that he's included in the local DNA index. And the third way is that below, the prosecution did in fact argue and seek that he be put in the local DNA identification index, and that's all on top of the policy that exists.
Counsel, I know there's a suppression motion pending. What's the status of that motion?
Your Honor, this case has been pending now for, I believe, 3 years or more. There's currently a 30-30 motion pending that we believe is meritorious.
Thank you.
Thank you.
Thank you both.
Not as quick as my colleagues.